All right. Ms. Grace, can you hear me?
Yes, ma'am.
Oh, thank you. Okay. All right. Good morning, ladies and gentlemen. My name is Judge Lal. I apologize for the delay, but let's get started with our state all-purpose calendar for today, September 5th, 2024. These are misdemeanor cases in which individuals have already been accused of one or more misdemeanor offenses. Bonds have already been set, and today we are going to determine how the defendant would like to move forward with their cases. So when I call your case, please remember that the defendant has a right to remain silent. Anything that you say in open court, your statements can and will be used against you. If you have a right to an attorney. If you cannot afford one will be appointed to represent you. Today, we are going to determine if the defendant would like to accept the state's offer to a particular offense or offenses, accept the recommended sentence, and take a plea, basically, or whether the defendant would like to enter a not guilty plea and have the case move forward for trial. Other matters I may be addressing are probation revocations, bond modifications, as well as bench warrants and motions to set aside. Courtroom 2, who do we have first?
We can go to position number 6, Mr. Cook.
Okay. Mr. Santravius Cook.
Yes.
All right. Okay. Let's see. Position number 6 is going to be Miss Atay. Okay. Good morning, Miss Atay.
Good morning.
All right, Miss Atay, let's begin with Mr. Cook. Mr. Cook is entering a not guilty plea to his particular case. And as soon as I can get to the page, there we are. His case number is 20 CR 5484D, 2 counts of reckless conduct and 1 count of tampering with evidence. Would that be correct?
Yes, Your Honor.
Okay. And are you filing a waiver of arraignment, or would you like?
Yes, I will.
Okay. Mr. Cook, your attorney will be filing a waiver of arraignment, which is essentially a entry of a not guilty plea, and your case will be further noticed for trial. Anything else?
Nothing from defense.
All right, thank you. Next case, please.
Yes. We can go to position number 14, Mr. Harris. Harris, you can have you ready.
This is State versus Richard Harris, accused of battery and possession of marijuana less than 1 ounce, 24 CR 5885Y. Mr. Harris, you've been advised of your rights. Your attorney is Mr. White, and this is going to be a negotiated plea. Mr. Harris, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
Thank you. Ms. Mokeke, good morning. And what is the recommended offer?
Good morning, Your Honor. The state's recommendation for count 1 is 12 months to serve 45 days, credit for time served 16 days. Stay away from the crystal located at 349 Cleveland Avenue, Southwest Atlanta. No further contact with Linda Faye Miller, FVIP, a BHET, and no firearms. And we will be no crossing count 2, the possession of marijuana charge. I would ask the defense to stipulate to venue, factual basis, and identification.
Mr. White? All right, thank you. Yes, go ahead.
I'm sorry, we would just ask to waive 3 months of his probation fees so that he can apply that to all of the fees for the course that he's taken.
All right, how many additional days does he have?
7 days, sorry.
Okay. Mr. Harris, have you consumed any medicine or alcohol?
No, ma'am.
Was that a no?
Yes, ma'am, I know.
All right. And have you understood what's going on in your case?
Yes, ma'am.
Are you satisfied with your attorney?
Yes, ma'am.
And are you entering this plea willingly, knowingly, and voluntarily?
Yes, ma'am.
If you decide to plead guilty to these charges, you would have to give up your constitutional right to a trial before a judge or a jury. You will not get the opportunity to have a trial, to confront your accuser, challenge the evidence that would be brought against you, to be able to present your own defenses and mitigating factors, and have the prosecutor carry its burden to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to one count of battery, family violence?
Guilty.
Your sentence is 12 months to serve 45 days, credit for time served 16 days. You have about 9 more days to serve at the jail, after which you will have to report to probation. You will report to probation on the first immediate weekday, which is either a Monday, a Tuesday, or a Thursday. While you're on probation, you are to stay away from the store, Crystal, I guess that's the hamburger store. And that's located at 349 Cleveland Avenue in Southwest Atlanta. You're to have no contact with Linda Faye Miller. You're to stay 200 yards away from her and not communicate with her in any way, form, or manner. Within 30 days of, well, we're going to waive the 3 months of probation, right? Yeah, so I'll waive the first 3 months of your probation fees. Within 45 days of being released, you are to enroll in a domestic violence intervention program. This is 24 weeks of classes. You must pay for those classes and attend every class until all 24 classes are completed, and you must present the certificate to your probation officer. Within 15 days of being released, you must go to a medical provider and undergo a BH evaluation and submit to any treatment that's required. At no time are you allowed to possess any firearms. Count 2, the marijuana charge is dismissed. Thank you.
Thank you, Your Honor.
You can say it. Next, we can go to position number 22, Mr. McClung.
You say, Mr. James McClung is going to be a negotiated plea. Gosh, I'm sorry, this case number cut off right here. Oh, there it is. Case number is 24 CR 5754E, accused of criminal trespass and willful obstruction of a law enforcement officer. Mr. McClung, you've been advised of your right. Your attorney is Mr. White, and may I place you under oath? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Ms. McCann, what's the offer, please?
Yes, Your Honor. The offer for count 1 is 12 months to run concurrent with count 2. Stay away from Fulton Scrap Metals located at 4255 Roosevelt Highway in South Fulton. The recommendation for count 2, willful obstruction, is 12 months, balance probated, a $300 fine, and 40 hours of community service. I would ask the defense to stipulate to venue, factual basis, and identification.
My calendar does not have an obstruction. I've just got a loitering and prowling.
All right, Mr. McClung has 2 counts.
I understand that.
You see 2 dates next to the date of offense date? Do you see 2 dates listed?
I don't. I
Oh,
literally, I literally see loitering and prowling, and that's the only thing I've got.
McClung. That your client, James McClung?
Yes, ma'am.
Criminal trespass.
I'm sorry. I'm sorry. I was looking at McClellan, the one above. Okay.
No worries at all. Okay. So Mr. White and Mr. McClung, are we on the same page? There are 2 charges against him, a criminal trespass, and willful obstruction.
Yes, ma'am.
Okay. And Mr. White, do you now stipulate to the factual basis, venue, and ID?
We do.
Thank you. Mr. McClung, have you consumed any medicine or alcohol?
No, ma'am.
And have you understood what's going on in your case?
Yes, ma'am.
Are you satisfied with your legal services?
Yes, ma'am, I am.
And are you entering your plea freely, willingly, and knowingly?
Yes, ma'am.
If you decide to enter this plea, you would have to give up your constitutional right to a trial.
Yes,
There
ma'am.
no trial, no confronting your accuser. You will not have the assistance of counsel to be able to challenge the evidence or present your own defenses and have the state prove the charges against you beyond a reasonable doubt.
Yes, ma'am.
Are you willing to waive these rights?
Yes, ma'am.
And how do you plead to criminal trespass and willful obstruction of an officer?
I plead guilty.
Your sentence on the count 1 trespass is going to be 12 months to run concurrent with the obstruction charge. And you are to stay away from the location of the Fulton Scrap Metals at
Yes, ma'am.
4255 Roosevelt Highway in South Fulton. That means you have to stay at least 200 yards away from that location.
Yes, ma'am.
With regard to the obstruction, it will be 12 months to be served on probation. You will, how long has he been in custody, Mr. White?
Our extra 4 days. So
4 days.
Yes.
All right, so it will be to serve 8 days, credit for time served 4 days, balance probated. You will pay a $300 fine while on probation and complete 40 hours of community service.
Yes,
You
ma'am.
I think you'll be reporting to probation, today's Thursday, on Monday, which will be September 9.
Don't have to.
September the 9th.
Yeah. September 9th. And report to probation. Will he be released, Mr. White? Does he have any other holds?
not as far as we see, Judge.
Okay. So September 9th is when you report to probation before 3 p.m.
Yes,
While
ma'am.
on probation, you will complete 40 hours of community service. You must
Yes, ma'am.
complete a minimum of 5 hours per month, beginning in the first month.
Okay.
And pay your $300 fine with a minimum payment of $30 per month and $30 every month thereafter.
Yes, ma'am.
Once, any objection to non-reporting, Ms. Mokeke?
No objection, Your Honor.
All right. Mr. McClung, the sooner you complete your community service and the sooner you pay off your $300 fine,
Yes, ma'am.
then your probation will be non-reporting. But that's
Yes,
up to
ma'am. Okay.
you. All right.
All right.
Okay. Thank you.
And you were talking about the probation. Maybe it should open them.
No, you gotta get up. I can see.
Thank you, please.
Next, we can go to position number 41 and 42, 41 and 40. 40 and 41, Mr. Woods.
Oh, God, thank you. I thought you made my calendar longer than expected, so you said 40 and 41, right?
Yeah, the numbers really just got me.
Yeah, the numbers are flip-flopped.
Kim,
Got it. Okay. Mr. Tracy Woods, you have been advised of your rights. Your attorney is going to be,
Ms. Kim,
Yes, I'm here, Your Honor.
Ms. Kim. Okay, thank you.
40 and 41.
All right. Ms. Kim, your client has 2 cases, 23 CR 001038F, accused of battery, family violence. And the second case is a bench warrant, 24 FTA 115. Mr. Woods has been advised of his rights, and this is going to be a negotiated plea. Mr. Woods, if you'd please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge? All right. And Ms. Falk, good morning. What's the offer for Mr. Woods?
Yes, Your Honor. State's offer is 12 months served, 34 days, credit for time served 17 days. That's going to be from February 22nd to February 23rd of 2023 and August 22nd of 2024 until today. Balance probated, FVIP, 40 hours of community service, no further violent contact with Jasmine Cullens. We also are agreeable to no crossing the FTA upon this plea.
All right.
State would ask the defense to stipulate to venue, factual basis, and identification for the purposes of the plea, and we would like to sound for Miss Jasmine Cullens.
Ms. Collins, she is present. And yes, Ms. Kim, do you stipulate to the factual basis, venue, and ID?
Yes, Your Honor.
All right. And Ms. Collins, if you could unmute,
Yes.
do you have any objection to this plea offer?
No, I do not.
All right, thank you so much. You may mute your screen.
Thank you.
Mr. Woods, have you consumed any medicine or alcohol?
No, ma'am.
Have you understood what's going on in your case?
Yes, ma'am.
Are you satisfied with your attorney?
Yes, ma'am.
And if you decide to plead guilty to this charge, you would have to give up your constitutional rights to a trial. You will not get the chance to confront your accuser, challenge the evidence, and present your own defenses and factors if you choose to do so, as well as have the state carry its burden to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to one count of battery, family violence?
Excuse me?
How do you plead to one count of battery, family violence?
Guilty.
Your sentence is 12 months to serve 34 days, credit for time served 17 days. The remainder of the time will be served on probation. You will report to probation on Monday, September 9th, before 3 p.m. The probation office is located at 132 Mitchell Street. While on probation, you will complete a domestic violence intervention program. You will enroll in that program within 45 days of being released. You are to also complete 40 hours of voluntary community service, with starting off with completing a minimum of 5 hours per month and 5 hours every month thereafter. At all times, you are to have no violent contact with Jasmine Cullens, which means there cannot be any physical or verbal altercations that may involve law enforcement. If you violate the no contact or fail to comply with probation, your probation can be revoked and you might have to complete the rest of the time in jail. Do you understand, sir?
Yes, ma'am.
All right. That completes your plea. Thank you.
Thank you.
Thank you.
Oh, the bench warrant is null pros.
Not from
Deputy, where are we going to now?
We can go to ACDE,
All right.
position number,
Good morning, Your Honor.
Good morning, Deputy Milton. How are you?
Good, thanks. Okay, coming up is position 19 and 20, Raven Jones.
Okay.
Your Honor, we might have to. Okay.
Courtroom 2, if you could mute your screen, please.
Mr. Ty is coming, this is her client.
Oh, I'm sorry. Okay. All right. Let me just make an announcement for Ms. Jones as well as the other individuals seated behind her. Good morning. My name is Judge Lal, and this is the Fulton County State Court misdemeanor calendar. We call this an all-purpose calendar. Today, we're going to determine how you would like to move forward with each of your respective cases. So, when I call your name and I address your case, please remember these very important rights. The first one is the right to remain silent. Anything that you say in open court, your statements can and will be used against you. You have a right to an attorney. If you cannot afford one, one will be appointed to represent you. Ms. Jones, you have two matters before us. The first is 21 CR 4953E, in which you were accused of theft by taking. And your second case, 24 FTA 1183, is a bench warrant. This is going to be a plea, Ms. Athay?
Yes, Your Honor, it's a negotiated plea. I am requesting that she be able to report to probation by phone because she does live in South Carolina.
Any objection from the state?
No objection, Your Honor.
All right. When is she moving to South Carolina?
She lives in South Carolina right now.
Okay. Her first visit has to be in person, which is coming up on Monday. September 9th. After the first visit, she will confirm her address with probation and all other contact details. And then we can set up a telephonic or email reporting, whichever probation deems to be convenient. And that way it will be conducted after the first in-person visit. Any objection, Ms. Atay?
No objection.
All right. Ms. Jones, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge? Do you need to speak up? Need to speak up.
Yes,
Yes.
ma'am.
Oh, that's very good. Thank you. All right, Ms. Mulcahy, may I have the offer for theft by taking?
Yes, Your Honor. The state's offer is 12 months to serve 34 days, credit for time served 17 days, balance probated, no further contact with Sawade Adabasan, stay away from 301 North Central Avenue, Atlanta, and an anti-theft course. And we will be no crossing the failure to appear.
Tay, do you stipulate to the factual basis, venue, and ID?
Yes, Your Honor.
Ms. Jones, have you consumed any medicine or alcohol?
No, ma'am.
Okay, very good. We are recording these proceedings and they have to be on file, so you need to speak up because we can't record a shaking of the head, okay?
Okay.
Have you understood what's going on in your case so far?
Yes, ma'am.
Are you satisfied with your attorney?
Yes, ma'am.
Are you entering this plea freely, willingly, and knowingly?
Yes, ma'am.
And Ms. Jones, if you decide to plead to this case, you would have to give up your constitutional right to a trial. We will not provide you with the opportunity to go back to court and confront your accuser, be able to challenge the evidence brought against you, present any defenses or mitigating factors if you choose to do so, and have the prosecutor carry her burden to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to one count of theft by taking?
Guilty.
Your sentence is 12 months to serve 34 days, credit for time served 17 days. You will be placed on probation with Fulton County Probation, and your first report date must be in person on Monday, September 9th at 132 Mitchell Street in downtown Atlanta, and it must be before 3 p.m. While on probation, after that, all your subsequent report dates can be either via phone or via email. I'm going to let probation set up that method, okay?
Yes, ma'am.
On your first visit with probation, you must update in writing your current mailing address, all your contact information, numbers, emails, and so forth. If any of this information changes, you must make sure that probation is the first person that you contact about those changes. Do you understand?
Yes, ma'am.
All right. While on probation, you will have no contact with Sijuat Adegbessen. If you know this person, then you probably know how to pronounce the name correctly, because I don't. But in either way, stay away from this person and stay away from 301 North Central Avenue. And while you're on probation, within 60 days, you will enroll in an anti-theft class and complete that class and provide the probation officer with a copy of that class certificate. Do you understand?
Yes, ma'am.
Before you enroll in any class, make sure that you confirm with your probation officer that the class is acceptable. Because if you're going to do it in another state, probation must verify and confirm that that class is acceptable. I certainly don't want you to do multiple classes. Do you understand?
Yes,
Okay.
ma'am.
All right.
Can the probation, at least 3 months of the fees be waived and go non-reporting after she completes the anti-theft course?
I will waive the first 2 months.
There was no trial.
Probation, do you charge for telephonic reporting? You do, right?
Certain that there is, he made a few mistakes.
I think they charge for everything.
So, if you
No, I don't see probation on Zoom. All right, yeah, I'll waive the first 2 months. The sooner she's done with her class, the better, then probation will be non-reporting.
Thank
Okay.
you.
I'll phone off.
Okay. Do you understand that, Ms. Jones?
Yes, ma'am.
All right, and bench warrant is null crossed. Thank you.
Thank you. Next, we have position 25, Latoya Moore.
Ms. Latoya Moore has a case 24 CR 5964E, in which she has been accused of 2 counts of battery family violence from August 23rd, 2024. Ms. Moore, you've been advised of your rights. Your attorney is Ms. Atay, and this is 25. And Ms. Atay, will you be filing a waiver of arraignment, or shall I?
Yes, I'll file a waiver of arraignment, Your Honor. This is a not guilty plea with a bond reduction argument.
Okay. And Ms. Moore, your attorney will be filing your not guilty plea on your behalf. And your case was going to be further notice for trial. In the meantime, let me just get your. Well, my honest is taking a long sweet time. Do you have the bond amounts that we are addressing?
Yes, well, Your Honor, there are 2 counts of battery family violence. I don't know why. I believe it should only be 1. I mean, in the plea offer, they're merging, but there's only 1 complaining witness, 1 date, 1 set of circumstances. So I don't know where the other one comes from. And the second charge has a $5,000 surety bond. The first one has a $5,000 surety bond. Her total bond is $10,000.
Mhm.
So she's 39 years old. The complaining witness is her 16-year-old daughter. The warrant stated that the officers observed injuries to Miss Moore, a bump on her head and a scratch on her lip. She states that the complaining witness, her daughter, was the first aggressor. Of course, she didn't want to say anything to get her daughter arrested. I'm asking for a bond reduction. She is a single mother. The father of this child and her other children has been deported and is in Jamaica. She does work full-time as a cashier at McDonald's. I realize that she does have an FTA, but she stated that she was struggling to find stable housing for her family, but she has a stable address now, 561 Arthur Street Southwest. She has a job. She has a minor child to take care of. So I am asking for, at the most, a $2,000 surety bond for 1 charge of battery family violence, so that she can get out of jail, get back to work, and taking care of her child.
Exchange maybe 2 words.
And how old is the child that she's looking after?
16.
Okay. And they've been living in Atlanta since how long?
She's been living in Atlanta for 14 years, and
Okay.
she works as a cashier at the McDonald's on West
I would
End.
like to see.
Okay, I'm just curious because you mentioned that someone was deported, so
The father
a
of her,
thought. Okay.
she is a single parent, the only person to take care of
I have been
of
trying
this
to find
16-year-old,
an attorney that can.
who's right now with
this program,
19-year-old daughter.
But I have
I
not
see.
found.
And I do apologize. As pleasant as Mr. White sounds, unfortunately, he's drowning out your comments. So
I'm sorry, Your Honor.
it's okay, Mr. White. It just tone it down a little bit. So
It's
sorry.
not Mr. White, Your Honor. There's somebody interviewing here for first appearance.
Oh, I'm so sorry. Okay, well then whoever was speaking, I couldn't quite hear what you were saying. So
Sorry.
I'm sorry, Mr. White. I thought it was you. So
I can repeat all of it if you want me to.
no, I got it now. That's why I just wanted to get all the information. Thank you. Ms. Falk, I do see that Ms. Moore has had a few encounters in 22 and then in 24, and this is her second arrest for this year. Anything else you'd like to add?
Yes, Your Honor. I would like to draw your attention to 22 CR 005751E. That is the sentence that Ms. Moore is currently under, dated March 7th of 2024, signed by Your Honor on March 7th, 2024. In that plea, the defendant was sentenced to 12 months, 38 days, credit for time served 19 days, is currently on probation, and as part of the probation was to have no further contact with the victim in this case and to engage in 24 weeks of domestic violence counseling. I'm not sure how much of that has been done. She was also told to report to probation by March 14th, 2024, to enroll in classes within 60 days of her release, and to do 40 hours of community service. She has violated the terms and conditions of that probation. Quite frankly, I'm not sure why we have not had a probation revocation filed by the probation department, being that she's in clear violation of those terms and conditions with this new offense 5 months later. Therefore, we ask that the bond remain as set, since she's currently not held to the terms of her current active probation involving the same victim. And we're also curious as to whether she's done any of the terms of condition that Your Honor ordered 60 days after her release in March.
All right, Miss
Case was gonna come up in 5 months.
Tate,
Your Honor,
you
there's
know, and I know that was going to come up. So how do we get over this little obstacle?
There's a no further contact with her daughter in another,
There is.
That's an illegal sentence.
I mean, then was her daughter placed into custody somewhere else?
Those were the terms that your
That's the
client
problem.
agreed to, PD Atai. So those were the terms, no further contact. She has violated those terms.
I didn't see that, Your Honor.
I'd be more than happy to send it over to Miss
Her
Atai, Your Honor.
16-year-old child, I think that, I mean, I don't know how.
We have no further contact with Zanoya Grant according to the bond order. So the bond order requires her to stay away. I don't know if DFACS is involved or whether that's another primary caretaker or an adult caretaker
There's
for the children. Okay, so then we have that issue.
So that's, I mean, that's not a legal order to order a parent not
To
to care
abandon
for their
her child.
child, then she could be arrested for that. I
Then DFACS would have gotten involved.
and they're not.
Yep, she agreed to the terms on March 7, 2024. If that was what she had agreed to at that time, I don't know if I can't even remember.
And she was represented by counsel, Your Honor. PD Vigiletti from the PD's office represented her at that time.
Well,
Judge, I would argue that's illegal.
those terms.
Judge, I would argue that's an illegal sentence that she couldn't agree to have, unless her child had been placed in some custody. She has a legal duty to her child to not abandon her.
I agree with you, but I'm assuming that PD Vigiletti had already inquired as to the status of the minor child and who was responsible for the child. You don't get to come back later and say that. So if y'all want to vacate that sentence, go ahead and file a motion to vacate that sentence, and we will have all 3 cases in place. But then we have the other problem, which is that according to the bond in 22 CR 5751E, and I just want to be sure. I mean, if Miss Vigiletti didn't know the child was 16 and they want to vacate that sentence, I mean, perfectly
I'm
fine.
sorry, Your Honor, what's the 22 CR?
Let me see. That she's got 2 cases in which she pled guilty, which was 21 CR 006270E, and sorry, the other one was disregard. Yeah, here's another one. 22 CR 005751E. There were 2 cases in which she took the plea.
That is correct, Your Honor. I only referenced 22 CR because that was the one that had those conditions.
So a case in what, I don't know.
Let me just clear it up. Okay. She took a plea in 2 cases, all right? And let's start with 22 CR 005751E. Battery, family violence, and cruelty in children at 3rd degree. She took that plea on March 7, 2024. Right, now let me get to 21 CR 6270E. Hey, I don't know, I'm just reading off this, because if I signed that disposition that Ms. Vigilante cleared it with the client, I'm willing to address a motion to vacate and take all three cases at the same time. Yep, March 7, 2024, same issue. Bad, reckless, and that was a reckless conduct, excuse me.
That is correct, Your Honor.
All right. So those were the two cases in which she took a plea. And in that plea, she was required to have no contact with the same victim as in this case. So
Well, Your Honor, I mean,
clearly, I now understand why Judge Mincy placed a $10,000 surety bond on this present matter.
Your Honor, I think at the most, it should be a $5,000 surety bond. I don't know what supports a second charge of battery family violence based on the warrant in this case.
Let's find out. Ms. Hall?
Yes, Your Honor. Let me just go back to the case in chief. And while we are inquiring about things, I still would like to know and would like an answer to whether she has done the conditions of her current probation that was ordered by Your Honor in March.
They are challenging the sentence, so let's.
I understand, but even without the no further contact, there were still other conditions. Family Violence Intervention Program and 40 hours of community service that were ordered to be done 60 days after her release.
All right, Ms. Falk, did your client do any of this sentence that's purportedly illegal?
Your Honor, I didn't inquire about that.
We don't know. Ms. Falk, we don't know.
Okay.
Go.
So in this situation, Your Honor, there were two separate parts of this fight, and there is case law that supports that where there is a break in the action and then a reinitiation of violence, that we can charge in two separate counts. I can pull that case up for Your Honor and provide that case information.
I'm familiar with it. So what exactly are you all charging her with on the two counts?
She, in one of the instances, she swung at the arrestee, swung at the victim, who then had a cut on her left arm and a bruise on her hand. And then she went back and bit the victim, who then had a bite mark on her right thigh. And so based upon that, we did charge two counts. One for the incident in which she was struck by the defendant, and then there was a break in the action, and then one for the incident in which she then bit the victim. And so that is the basis of the two counts. And again, I believe that Judge Mincy ordered the bond that she ordered based upon the previous conviction that she's currently on probation for.
All right, there you have it, Ms. Latay. Anything else?
I am requesting at the most a $5,000 surety bond be set. If Your Honor wants to split that up between two charges, $2,500 each, but I'm asking at the most a $5,000 surety bond, Your Honor. This the warrant does state that the officer observed injuries to my client. She states that the complaining witness, her 16-year-old daughter, was the first aggressor. And she has minor children that she has to care for. In the plea offer, the state is requesting no further violent contact with Ziona Grant, recognizing that this is her minor child that she is responsible to take care of.
Is there a Ziona Grant on Zoom? No. Okay. So right now I have two, possibly three open cases if I vacate the sentence in the other two cases. Is the public defender going to be filing a motion to vacate the sentence?
Your Honor, I need to look into it, but of course, I would at least change that.
We don't know at this point, Judge.
All right. So presently, given the nature of the fact that she already pled guilty with the assistance of counsel, that she agreed to have no contact with this individual which you all claim is 16 years old, and that apparently, according to the defendant herself, she has had multiple cases of violence against the same individual. Same individual. I don't have a problem with the bond amount. I'm going to keep it the same. And I'm going to require the prosecutor's office to get in touch with the Department of Family and Children's Services to inquire as to the welfare of the minor children belonging to Miss Latoya Lee Moore.
Yes, Your Honor.
To their status. So as a statutory reporter, you have to contact defects and you have to notify that there are minor children involved and that they belong to Miss Moore, who's presently incarcerated at the Fulton County Jail. And then the Public Defender's Office, if you believe that this sentence was issued in error, then y'all have a duty to file the appropriate motion and we'll vacate the sentences and address all three cases at the same time. And I am perfectly happy to do all that. You just need to let me know when the motions are filed and we can take it up. But Miss Moore is charged with 3 cases involving violence with a minor, and defects has to be involved. If someone tells me they don't know why, then we're going to resolve that by having the prosecutor contact defects and get them involved.
Your Honor, she can't afford a $10,000 bond,
No,
so she,
I'm sorry to hear that. But again, I can't afford to give her a signature bond where she might reoffend or cause more harm to these individual victims.
Your Honor, I didn't ask for a signature bond. I asked for at the most a $5,000 bond. That's a high bond for a misdemeanor.
I'm setting a bond which I believe will reflect a curb on her propensity to reoffend.
What bond are you setting?
The $10,000 bond. I have no problem with that bond. Open case, an arrest in 22 and 2 cases in 2024. All right, thank you. Bond modifications denied. Next case, please.
Next, we have, position 36 and 37, Obiwencia. Have a seat, please. And FYI, Your Honor, position 31, LeVard Reed. He told me that he has a private attorney, Matthew Carrington.
Oh, okay. Let's hope Mr. LeVar's attorney is here. I don't see a Matthew Carrington. Oh, that's the one we were trying to trace down. Okay. And who did you say is presently before me?
36 and 37.
Okay. I think Miss Bridgewater was trying to, no, was it Miss Grace? I can't recall. Someone was trying to track down Matthew Carrington. So, all right. 35 and 36 is, oh, sorry. That's an Antoine Thompson. Are you Mr. Thompson?
No, Your Honor, it's 36.
Oh,
and
the other one.
37.
Okay. Ubek Wenisha. Are you Mr. Ubek Wenisha?
Yes.
Miss Ubek Wenisha. Okay.
Yes.
And first name is Tessan. Have I completely butchered your names?
No, ma'am.
Oh, okay. Oh. Miss Ubek Wenisha is accused of criminal trespass, 2 counts, at the Presbyterian Church at Roswell Road. Cases are 24 CR 4105E and 24 CR 5928E. Ms. Ubek-Wenisha, you have been advised of your rights. Your attorney is Ms. Atay. And with regards to both matters, this is going to be a negotiated plea. May I place you under oath? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
Okay, thank you. Ms. Falk?
Yes, Your Honor. The state's recommendation is 12 months probation on the first case, is 12 months probation concurrent with case 24 CR 0059828E. Stay away from the Presbyterian Church located at 3434 Roswell Road. On case number 2, the state's recommendation is 12 months served 30 days, credit for time served 15 days from August 22nd, 2024 until today. Balance suspended and stay away from the Presbyterian Church located at 3434 Roswell Road. We do ask the defense to stipulate to venue, factual basis, and identification for the purposes of this plea.
We stipulate, Your Honor, and I just want to clarify that the balance is suspended.
That is correct.
Okay, on both positions. Okay.
Correct.
Yes, because the first case runs concurrent with the second case, which the balance is suspended on.
Thank you.
All right, Ms. Vic-Vinisher, do you, please unmute, Deputy Milton? Thank you. Yes, do you, have you consumed any medicine or alcohol?
No, no, ma'am.
And have you understood what's going on in your cases?
Yes,
Are you satisfied with your legal services?
yes,
And is anyone forcing you to accept this plea today?
no, no,
If you decide to do so, you would have to give up your constitutional right to a trial. You will not get the chance to confront your accuser, have the assistance of counsel during trial to challenge the evidence brought against you, and present your own defenses. You will also lose the opportunity to have the state carry its burden to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
yes,
How do you plead to
Yes.
2 separate counts of criminal trespass at the same location?
guilty to both.
All right, on position 36 is 12 months concurrent with the second case, and you are to stay away from the Presbyterian Church at 3434 Roswell Road. With regards to the second case, it's 12 months to serve 30 days, credit for time served 15 days, balance suspended. You are again to stay away from the Presbyterian Church. If you are of that religious inclination, you will have to find a separate church. You cannot return to the Presbyterian Church at Roswell Road, otherwise you will be arrested again and you'll be back in jail. Understood?
Yes.
That concludes your plea.
Thank you, Jesus. Have a good day.
Thank you. Jail court iPhone.
Good morning. We have position number 21, Mr. McClellan.
Okay. Thank you, sir. 21, Mr. Jason McClellan, represented by Mr. White. And Mr. McClellan is 24 CR 5963J, accused of loitering and prowling. That's
Okay.
the McClellan we were talking about, isn't that correct?
That's correct. They're right next to each other on the calendar.
I
So,
understand. Totally. Okay, Mr. McClellan, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney and your counsel, Mr. Tom White. And this is going to be a negotiated plea. Mr. McClellan, please raise your right hand and unmute jail court iPhone, please. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you, sir. Ms. McClellan, what's our recommendation?
Yes, Your Honor. The state's recommendation is 12 months to serve 28 days, credit for time served 14 days, balance probated, stay away from the Children's Learning Adventure Center located at 13175 Cogborn Road in Milton, and either an ADET or a BHET. Based on the warrant, I'm not sure if the defendant's behavior was caused by a behavioral mental health problem or an alcohol and drug problem. I'm sure the defense can speak more to that. So
and
that's why
Judge,
we have an option to choose.
we have a resolution, slight tweak. He's agreed to just go to AA. That's his problem. He doesn't need an evaluation. He already understands that he has an alcohol problem. And he doesn't have the money for the assessment, but he's just agreed as part of probation that he will go to AA and he can show proof to
Then you
probation.
could do a alcohol and drug evaluation at Grady as well. There's no expense required. And if he complies with AA, that's perfectly fine too. But he needs to do one or the other. Which one would we go with?
One of the other, what's that?
Is he willing to do an alcohol and drug evaluation? You can do it at Grady. You can do it at any health facility that offers free services for the indigent.
I mean, as long as it's free, I don't think you'd have a problem with that.
Okay, then I'll require
let me-
him to,
Well, Judge, can I ask him?
oh, sorry, yeah, sure.
Did you, Mr. McClellan, did you hear that?
Yes, but, so my question is, so I'd have time served, okay? And I'd get out today. And so I would have to have this, evaluation done at Grady at what point?
I will let you know, but right now we are at the stage where the question is, if you accept this plea offer and freely, willingly, and knowingly waive your constitutional rights to a trial, you will then I will proceed with a plea hearing, and if I accept it, you will be convicted of this offense and placed on probation. And while you're on probation, you'll be required to do an alcohol and drug evaluation with a qualified healthcare provider like Grady Hospital. And if you want to go on AA, Alcoholic Anonymous, then you will be required to show proof of your attendance to your probation officer for the remainder of your sentence, which is 11 months and 2 days. So let me just clarify that time served is different from being on probation.
Judge, he understands all of that. I think his question was.
No, I just want to be sure that I hear it from him, that he understands that.
Judge, I don't even live in the area. And, to be put on.
I just want to be sure you understand that you'll be on probation if you accept this offer. Apparently, that was a stickler point. Mr. White?
Mr. McClellan, as we discussed yesterday, you understand that there is a probated requirement to this plea, right? Where you'll have to report to probation.
Where I have to report to probation?
Yes. We discussed this yesterday. You'd be on probation. Probation requires reporting. Now, we could probably get it to where it's by phone or mail if you don't live in the area, but you do understand probation, correct?
Yes, I know probation.
Okay. And Judge, I think his biggest question was when he would be required to do this thing at Grady, especially considering he doesn't live in the area. We're willing to skip the middleman and just say, we admit there's a problem, go straight to AA. I don't understand why there has to be an evaluation that's going to come back that says he has a problem when we say there's a problem.
And I'll tell you why, Mr. White. I'll tell you why. My experience is that if I'm going to make AA a condition of probation, I want to have an evaluation done. Now, whether he voluntarily decides to go to AA, that's a different matter. But I want the underlying evaluation done. Okay, so that's my rationale.
All right.
So apparently, Mr. McClellan is not keen on probation. So
Judge, you haven't said that.
Oh, okay. So, Mr. McClellan, would you like to hear the plea offer again, or?
No, I'm good. I'm good with what you got.
All right.
I'm guilty for that.
Okay. Ms. Mokeke, have you had a chance to articulate? I've forgotten what had transpired. Have you allocated the offer?
Have I allocated our plea offer?
The offer, right? ADHET. Okay. So, Mr. White, will your client do an alcohol and drug evaluation or a behavioral evaluation?
Judge, you can go to Grady and do the free evaluation. We'll make that happen. You in agreement?
It's also free if he goes to the correct healthcare provider. Right now, I am fairly certain it is at Grady Hospital.
Okay.
And Mr. White, do you stipulate to the factual basis, venue, and ID?
You do.
Mr. McClellan, have you consumed any medicine or alcohol?
No.
And have you understood what's going on in your case?
Yes,
And are you satisfied with your legal services?
yes,
Are you entering this plea freely, willingly, and knowingly?
yes,
And if you decide to plead guilty to one count of loitering and prowling, you will have to give up your right to a trial. You will not be able to come back to court. You will not be able to confront your accuser, challenge the evidence brought against you, present your own defenses and mitigating factors, and also have the state prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
yes,
How do you plead to one count of loitering and prowling at the Children's Learning Adventure on Cogburn Road in Milton?
guilty.
Your sentence is 12 months to serve 28 days, credit for time served 14 days. Your jail time is concluded, but you will have to report to probation on Monday, September 9th, before 3 p.m. The Fulton County Probation Office is located at 132 Mitchell Street in downtown Atlanta. You will report to probation every month, once a month. And while on probation, you will submit to an alcohol and drug evaluation and submit yourself to any treatment that's required. You must submit within 15 days upon being released from the Fulton County Jail. You may go to any qualified healthcare provider, including Brady Hospital, to complete the evaluation. If you decide to enroll and participate in Alcoholic Anonymous classes, I need to know now whether you plan to enroll and attend those classes.
Judge, why do we need to know now whether you plan to do that?
Y'all said you all wanted to, but if you are keeping that as an open option, that's entirely up to Mr.
Yeah. That was in lieu of the ADET. So now since you're forcing me to ADET, we're not going to agree to that.
Okay, that's perfectly fine. I just want to be sure. So I'm not going to order AA classes. However, if the alcohol and drug evaluation requires that Mr. McClellan attend some kind of program like AA or similar to it, he will be required to comply and submit to that treatment. Anything else, Mr. White?
Yes, Your Honor. We would ask that you waive, since you're going to be requiring him, it's likely that he'll be on the entire time to waive all 12 months of fees. He has no income, and that he'd be allowed to report by phone or mail since he doesn't live in the area.
Okay. What is his age? 1981. Okay.
It'd be 43-ish.
Okay. And where does he live?
I don't have an address. I'm homeless.
So I am going to require him to report once a month in person. Since he doesn't live far away.
In the system.
I beg your pardon? I'm sorry, Mr. McClellan? If
No.
you don't live far away, then there's no requirement for telephonic reporting. I don't think he is interested in this plea offer, Mr. White. I really get the vibe that he's not going to comply.
Well, that's because the court keeps setting him up to fail.
Okay. In that case, then I am going to not accept this plea offer, and we're going to further notice this case for trial. I certainly don't want to set him up for failure. So
And allow him to report by phone and mail instead of having to travel from work.
No, he has to report in person. So if that's
why is his case different than
no,
the
Mr. White, I'm no, this plea is off.
Is it okay?
No, I'm revoking my my decision, and we're going to set this case up for trial, because I certainly don't want to set your client up for failure. That is never my intention. But if he has a problem with alcohol, he needs to understand the sentence is going to be curated to address that. But right now,
well, we're not addressing an alcohol issue. We're addressing a income issue and viability for travel.
And I'm waiving probation fees so that he can take time to get a job, but he must report to probation. He doesn't live far away. He just doesn't live, he's homeless. He said that.
We can do that.
All right. No, I'm not arguing with you guys. We're going to reset this for next week and we can address this again.
Judge, He'll make it work. I mean, he's already been in jail for 14 days.
I can make it work, especially if you waive my fees for probation. then
Yeah, for 3 months.
I can
3
make
months.
this work.
For 3 months, Mr. McClellan. You're not an old man.
I know.
Get a job. You can figure it out.
Yes, ma'am.
But if you don't report to probation once a month, we'll have you invited back to jail.
I understand that,
Nope.
but I would really like to get out today and go ahead.
But if your attorney tells me that I'm setting you up for failure, I don't want to do that.
And I can
He
handle
said,
it.
we have said a couple of times that we'll make it work.
All right. I'll reinstate the sentence, and he needs to report once a month. And he needs to provide a valid phone number and email or any kind of communication to his probation officer. And like I said, he needs to do the alcohol and drug evaluation at any qualified health facility, but in-person reporting. Probation fees waived for the first 3 months, and he needs to figure out how to get a job and get himself to becoming a productive member of the community. Thank you.
All right, thank you.
I'm sorry, did he just say the F word, officer?
No, he didn't say it.
All right, just want to be sure.
Yeah.
Okay,
Next we have position number 3, Mr. Benz.
give me the position number again.
3.
3, okay.
She's on.
Is this no, give me that position number again. Oh, hang on, I'm looking at the bench warrant calendar. All right, there we go. Miss McLeod, is that your client?
Yes, Your Honor, good morning.
Good morning. Okay, so we have Mr. Mark Binns with 2 N's. Case 24 CR 5962Y, accused of simple battery and willful obstruction of an officer. Oh, and count 3 is also simple battery. So 2 counts of simple battery. And then Ms. McLeod, your client has another case, 23 CR 779J, criminal trespass. So we are addressing 2 separate cases. How Mr. Binns has been advised of his rights, and Ms. McLeod, how's your client proceeding today?
He wants to enter a plea of not guilty, Your Honor, and I'll be filing a waiver for arraignment and a demand for speedy trial on his behalf.
Okay, demand for speedy trial. Have you filed this demand already?
No, Your Honor, I will be filing it today.
All right. The state is on notice that the defendant is filing a waiver of arraignment and a demand for a speedy trial. So,
Yes, Your Honor.
right. So Ms. McKechnie, please make a note that to let the division judge know that it needs to be scheduled for trial within the appropriate term.
That is correct, Your Honor.
Okay. And anything else, Ms. McLeod?
No, that is all for Mr. Benz this morning, Your Honor.
All right, thank you. Mr. Binns, your case is going to be transferred to the division judge and scheduled for trial. I do not have a date, but it will definitely be within this term or the next. Thank you.
Thank you, Your Honor.
Have a seat. I'm gonna let you know. We can go to position number. 1 second, Your Honor. Position number 12 and 13, Mr. Grigsby.
Okay. Oh, that was Ms. McLeod too. Okay,
Yes,
thank you.
this is my case, Your Honor. This is going to be a negotiated plea this morning.
All righty. And I just want to make sure 2 cases, right? No other add-ons. Okay.
That is correct, Your Honor.
Derek Grigsby is represented by Ms. McLeod. He's been advised of his right to remain silent. His first case, position 12, is 23 CR 4406G. in which she's accused of reckless conduct and disorderly conduct from July 12th, 2023. His second case is 24 CR 1591G, accused of battery family violence, in which he's accused, and the accused date is April 2nd, 2024. Mr. Grigsby, if you please raise your right hand for purposes of the plea. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
To the best of my knowledge, agree.
Okay. And Ms. Mokeke, what is the plea offer for these two cases?
Yes, Your Honor. The plea offer for the first case, reckless conduct and disorderly conduct, is time served 318 days, credit for time served 159 days. The plea offer for the battery family violence is 12 months consecutive to case 24 CR 004406G. Balance probated, no further contact with Mary Grigsby, stay away from 789 Humphrey Street, Southwest Atlanta, and no firearms. We are also asking for an FVIP, and that probation can terminate upon completion of that FVIP.
Okay.
I would ask the court to sound for Ms. Grigsby. She did indicate that she may be on the Zoom today.
Mary Grigsby, if you are on Zoom, please unmute. I have one iPhone. I don't know who's on that one, but no one. With the person on iPhone, please unmute and start your video. All right.
Yes.
Are you Mary Grigsby?
Yes, ma'am.
Okay, thank you. We can rename iPhone to Mary Grigsby, Miss Grace. All right. Miss Grigsby, we are considering a plea and sentencing of a case involving Derek Grigsby. Have you heard the proposed sentence?
Yes.
Which will require Derek Grigsby to stay away from 789 Humphrey Street and have no contact with you.
May I say something?
Sure, go ahead.
Will he be able to have a place to go to and stay?
That's entirely up to him. But he can't stay with you and he can't have any contact with you.
Can I change that?
Miss, you would have to contact the prosecutor's office if you want to speak with them.
I would like to change that because he's not going to have nowhere to go. So he would have to come home, but it should be some restrictions if he comes to the house.
It'll have to be what?
Some restrictions when he comes to the house.
What kind of restrictions would that be?
No contact with me at all. Just stay in his room and do what he go to work if he can.
All right. Okay, but you want to have no contact with him. Is that correct?
I'm willing. She's asking that I not.
Mr. Grigsby, I'm not talking to you. Ms. Grigsby, do you want to have any contact with him?
He have to have contact with me because he have to come to the house to stay in his room and go look for a job. Yes, I don't mind him coming to the house, long as he don't interact and say something or do anything to me. But other than that, he have to have a place to stay.
That I cannot guarantee. He's a grown man and I cannot guarantee that.
Well, then he had to come to the house then.
All right. Thank you, Ms. Grigsby.
And Your Honor, the state would object to that, given the facts of this particular case and the facts of his reckless conduct case. Previously, the victim did state that she was in agreement with the plea offer. I understand this is a mother concerned about the well-being of her son, but as the state, we are concerned about the well-being of Ms. Grigsby, and we want her to be safe and protected. And we cannot guarantee that that will happen if the defendant is allowed to go back home.
All right. Thank you. Ms. McLeod, anything to add?
Yes, Your Honor. My client essentially has nowhere else to go because we've spoken about it on several occasions, and I guess he's probably will have to go to shelter because he's been locked up for quite some time and he really doesn't have the resources to find accommodation. And also with respect to his probation, I would definitely ask for a waiver for at least a minimum of the first 3 months, because I believe the course the state is asking him to take is a 24-week course.
I was going to waive it for 6 months while he.
6 months would be perfect, Your Honor, to allow him
I don't have a problem with that. My
to get
question
it done.
housing. My question is housing. So,
Yes,
so your client will be essentially homeless if
that
he
is correct, Your
accepts
Honor.
the offer involving the victim, Mary Grigsby.
Can we change that to no violent contact?
No.
So I would say, Your Honor, that he probably can find some temporary accommodation, a shelter or something until he can get on his feet. But he's been locked up for a very long time. I spoke with Mr. Grigsby on Sunday because he was in Cobb County. I went to see him there, and I've spoken to him again this morning, and he's anxious to get out to see if he can get his life back. And he tells me that normally he does have a CDL, and he thinks that at some point he probably can go back to doing that. But I think maybe a shelter would work in the short term.
I'm glad you see it my way then. Thank you. Mr. Grigsby, if you decide to accept medical, I'll be with you very shortly.
No,
go ahead.
Judge Law, I have the chaplain up here. He's stating that he can find him somewhere to go.
Oh,
wonderful.
All right.
So 314 Peter Street.
I'm gonna have two questions.
They'll take him in at Peter Street if he'll go. It's the Atlantic City Baptist Rescue, and they have a 6-month program that he can sign up for there. They'll house him there. They got clothes, they house, they feed. He can stay there. 6-month program, no communication with the outside. They'll, cell phones, none of that kind of stuff. They take all that away if you join their discipleship program, but they'll take you in, walk in. You can just show up, knock on the door. Mr. Hill runs that program, and they take guys in. Now, they do discipleship training all through the week. They do preaching on Friday. And so it is a Christian base. So if you don't want that, then don't show up.
May I
Is the address of that facility?
I'm sorry. Hang on, folks. Hang on. Chaplain, may I have the address of that location?
That's 314 Peter Street.
314 Peter Street. Okay, thank you. Ms. McLeod, what was your question?
I was asking the same thing, Your Honor, the location of the facility.
Okay.
The address.
Thank you. All right. Thank you, Chaplain. I really appreciate it. Deputy, thank you so much for chiming in. Appreciate it. Thank you. Okay. Now unmute courtroom 2. All right. Mr. Grigsby, what was your 2 questions?
So it's kind of 3 now because of his thing. But the base one was, I'm one of the owners of that address. So I'm willing I'm asking for the 1-year restriction until the family violence program is completed from the address. Because the witness
you're giving me.
You don't discuss any of that. We're taking your plea now. I don't think you should talk about that now. Okay.
What is your question? What is your question? Unmute.
Is the restriction only until the end of probation?
The condition of probation is that you have to complete the domestic violence intervention program, and once you have completed the 24-week program, then your probation will terminate. After that, the restrictions also removed, correct?
Thank you.
However, no, sorry, courtroom 2, you cannot unmute. He has 2 more questions. However, not yet. I haven't finished my response. However, if Mary Grigsby, after you completed your probation, if Mary Grigsby says you cannot come onto her property, you have to respect that and stay away from the location and stay away from her.
I am one of the owners of that property. That's the problem.
Mr. Grigsby, you can discuss that with me, please. We're not going to go there this morning.
All right. Unmute courtroom 2. Question number 2.
No, you answered both questions.
And you said you had a 3rd question. Have I answered all your?
I wanted the full address to the thing that he had.
314 Peter Street, Atlanta, Georgia.
Was there a zip code?
No, I didn't catch a zip code.
Did you test the program that he said? The actual, never mind. I'll figure
Down
it.
Atlanta.
Get up and down.
It's
Close
fine.
to downtown, I
I'll figure
believe.
it out. I'll figure it out. I'm intelligent fellow. I'll figure it out.
All right. Anything else, Mr. Grigsby?
No.
Okay. So, Ms. McLeod, do you stipulate to the factual basis, venue, and ID for both cases?
Yes, Your Honor, we do.
Okay. Mr. Grigsby, you've already been sworn. Have you consumed any medicine or alcohol recently?
No.
Have you understood what's going on in both your cases?
To the best of my knowledge.
And if you decide, are you satisfied with your legal services?
Based on the current understandings of the facts.
I have no idea what you just said.
Yes.
Sit up straight and tell me, are you satisfied with your legal services?
Yes.
And are you entering this plea freely, willingly, and knowingly?
Yes.
If you decide to plead guilty to both these cases, you would have to give up your constitutional right to a trial before a judge or a jury. You will not have the opportunity to go back to court with your lawyer, to confront your accusers, to challenge the evidence that we brought before you, to have the assistance of counsel to present your arguments, mitigating factors, and defenses if you choose to do so, and to have the state carry its burden to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes.
You understand that by entering this plea, one of the charges is battery family violence. If you ever get arrested again for a same or similar offense, that new arrest will be automatically a felony charge. Have you been informed of this?
One question. I have. There's one variable associated with that, which you're saying that as long as if it's the same party or a different party, it doesn't matter.
It doesn't matter. If you get arrested again for battery family violence in the future, and you have this particular charge as a conviction on your record, that subsequent charge will be a felony charge.
Okay.
Are you still willing to move forward with this plea?
Yes.
And you understand there is no right to file an appeal once I sentence you.
Agreed.
In case 23 CR 004-406G, how do you plead to reckless conduct and disorderly conduct?
Guilty.
Your sentence is 12 months, so 308. Credit for time served 159 days, and that concludes your sentence for that case. In case 24 CR 001591G, how do you plead to one count of battery family violence?
Guilty.
Your sentence is 12 months to serve consecutive to the prior case, and that will be probated for 1 year. While you are on probation, you will report to the probation office on Monday, September 9th before 3 p.m. The probation office is located at 132 Mitchell Street in downtown Atlanta. While you are on probation, you shall have no contact with Mary Grigsby. You are to stay 200 yards away from Mary Grigsby and not communicate with her in any way, form, or manner, including in-person, mail, email, phone, electronic devices, through a third party, and even on social media. You are to stay 200 yards away from 789 Humphreys Street in Southwest Atlanta. You are not allowed by law to possess any firearms for the rest of your life due to a family violence conviction. While you're on probation, you will enroll in a domestic violence intervention program, and you will enroll in that program within 45 days from today. You are to attend all the classes without any absences, and that is a series of 24 classes once a week. Once you complete the domestic violence intervention program, your probation will terminate. Of course, upon completion of your probation and which it terminates, you are allowed to have contact with Mary Grigsby. And however, if Miss Grigsby indicates that she does not want you at the property at 789 Humphrey Street in Southwest Atlanta, you are required to comply with her request, with her desire. If you fail to comply with her desire, you can be arrested for criminal trespass. If you believe that you are a joint property owner, you would need to assert those rights by obtaining relief through the civil courts process. Understood, Mr. Grigsby?
One question.
Yes, sir. Yes, sir.
My property, at the property. I would need, can I have at least 100 days to establish, well, I need 2 visits, at least 2, minimum 2, to say max of 3, to cover my property from the property or enough property.
Property do you have? Recording. What property do you have?
Oh, my assets that are at the residence. So
What property do you have?
Office equipment, all my office equipment, office equipment, kitchenette, there's roughly about a small apartment worth of items at the facility. So that's why I was saying I need at least.
Listen very carefully now.
Yes.
As part of the sentence, you are allowed a one-time visit, one time, with a police officer. A police officer must accompany you to the property. This visit must take place within 60 days from today. And when you go to the property, you must hire the appropriate moving service and movers in order to facilitate the removal of any items that you claim belong to you. The visit cannot exceed 2 hours. And during the course of these 2 hours, if there are any items whose ownership is in dispute, you shall leave those items behind and you may seek recourse through the civil courts. And that recourse can only be conducted after your probation is terminated. That concludes the sentence. Ms. McLeod, any comments?
No, Your Honor, we have already agreed that his probation fees would be waived for the 6 months in order to give him the opportunity to complete the FVIP.
Correct. Any questions, Mr. Grigsby? None. Thank you.
No.
Completes the case.
Judge
Thank you, Your
Law,
Honor.
there was a correction in the address. It's 316 Peter Street instead of 314.
Do you have a zip code?
16.
30313.
30313?
Yes, ma'am.
Thank you so much. I appreciate all your help. It's really bad.
30313 Peter Street?
Yes, ma'am. 316 Peter Street instead of 314. Zip code is 30313.
Okay, 30313. Thank you very much.
All right.
Okay.
Courtroom 2, I have jail court iPhone. Shall I go there or shall I address anyone in courtroom 2?
We do jail court iPhone.
Oh, jail court iPhone, who do we have?
Before we go with him, Miss McLeod, she was just gone. I have one of her clients, Mr. Plummer. Do you need to speak with him before we put him on?
I do need to speak to Mr. Plummer, yes.
Okay.
Okay, we'll call you. We'll call you with Mr. Plummer on.
Okay, great. Thank you.
All right. But this is position number 28, Mr. Pellet.
Thank you. I have a Zoom user. Who is this person? The gentleman in a black shirt. Please unmute.
My name is Orlando Morrow.
And which case are you here for?
Back on Sierra Taffy.
Judge, he's on the DV benchmark calendar.
Okay. All right. Yes, sir. We will be with you in about 20 minutes or so.
Okay.
I'm sorry. Jail court iPhone, give me that name again.
Position number 28, Mr. Pellet.
Yeah. Virgilio Pello Hernandez. Are you Mr. Pello Hernandez?
Yes, ma'am.
Or is it Peyo Hernandez?
Excuse me?
How do you pronounce your last name?
Pellot.
No, how do you pronounce it?
Oh, Pello.
Pello, okay. All right, case number is 24CR5931J. Mr. Pello Hernandez is accused of battery, family violence, and obstructing or hindering a person from making an emergency phone call from June 22nd, 2024. You have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and if you cannot afford one, Ms. Kim will be representing you. Ms. Kim, with regards to Mr. Pello Hernandez, this is going to be a negotiated plea. Would that be correct?
Yes, Your Honor.
All right. Mr. Pello Hernandez, please raise your right hand. Do you solemnly swear and affirm? The other hand? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Ms. Falk?
Yes, Your Honor. On count one, the family violence battery, the state's recommendation is 12 months, serve 120 days, credit for time served 15 days, from August 22nd, 2024 until today. Balance probated, FVIP, stay away from 12 Lazy Waters Drive in Cartersville, no further contact with Minerva Arroyo, and 40 hours of community service. Count two, the obstruction of hindering of a person making an emergency call is 12 months, serve 120 days, credit for 15 days from August 22nd, 2024 until today, concurrent with count one. We did have an opportunity to speak with Ms. Arroyo. She is in agreement with the plea offer, and although she stated she will not be on Zoom today, we would like to sound for her out of an abundance of caution. We also asked the defense to stipulate to venue factual basis and identification for the purposes of this plea. That's all for the state.
Minerva Arroyo, if you are present. Don't see anyone. Okay. Miss Kim, do you stipulate?
Yes, we stipulate.
Okay. Mr. Pello Hernandez, have you consumed any medicine or alcohol?
No, ma'am.
Have you understood what's going on in your case?
Yes, ma'am.
And are you satisfied with your legal services?
Yes, ma'am.
Are you entering this plea freely, willingly, and knowingly?
Excuse me?
Are you entering a guilty plea freely, willingly, and knowingly?
Yeah.
And if you do so, you understand that you will be giving up your right to a trial. You will not be able to have a trial before a judge or a jury. You will not get a chance to confront the accuser, be able to challenge the evidence brought against you, present your defenses and arguments, and have the prosecutor prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to one count of battery, family violence, and one count of hindering a person from an emergency phone call?
Guilty.
Your sentence for count one is 12 months to serve 120 days, credit for time served 15 days. You have about 45 more days to serve at the Fulton County Jail. After the 45 days, you will then be released and placed on probation if you have no other cases against you. You will report to probation on the first available weekday before 3 p.m., and that would be on a Monday, Tuesday, or Thursday. Probation office is located at 132 Mitchell Street in downtown Atlanta. While on probation, you will enroll in a domestic violence intervention program within 30 days of being released. You will complete 40 hours of community service with any nonprofit agency that's not a church and a school, and you must begin with completing 5 hours per month and 5 hours every month thereafter. At all times, you are to stay away from 12 Lazy Waters Drive in Cartersville, Georgia, and have no contact with Minerva Arroyo. On count two, obstructing or hindering a person from making an emergency phone call, your sentence is 12 months to serve 120 days, credit for time served 15 days, concurrent with count one. Thank you. Any questions, Ms. Kim?
No question, Your Honor.
Right.
I got a question.
That concludes the sentence. Thank you.
Come on, man.
Yeah, I got a question.
All right, what's the question?
So I'm not going to get released today?
No, sir, it's 120 days credit for time served 15 days. Were you told differently?
Uh-huh.
Can I call you? Can I talk to you a little bit later?
Yeah, I got a misunderstanding.
I'm sorry?
Yeah, I got a misunderstanding. So how many days I got left?
45 more days.
Okay, thank you.
Well, it's 45 divided by 2, right? No, it's 45 more days. 45 more days, that's correct. Okay.
Thank you.
Right now?
Jail court iPhone, did you have another case?
If Ms. McLeod is ready, we have Mr. Plummer right here.
All right, let me go ahead to courtroom 2 and then I'll be right with you. Okay, courtroom 2, are we ready to proceed? Please unmute.
Not yet, Your Honor. She's conferring with her client.
Okay, thank you, courtroom 2. Jail court iPhone?
Yes, we have Ms. McLeod's client right here, Mr. Plummer.
Mr. Plummer, okay. And Deputy Milton, did you have a question?
Yes, were you all able to get in touch with Miss Attorney Matthew Carrington?
We had tried to track him down. We don't see I mean, this was from like 3 weeks ago, but I don't see a Matthew Carrington on the Zoom.
Okay, no problem.
If he has any contact information for Matthew Carrington, that would be great because we couldn't track down this person.
Okay, thank you.
Thank you.
And Your Honor, we're sure it's Matthew Carrington and not Carrington Matthews.
I thought it was Carrington Matthews, but apparently
that's what I thought too. Okay, I just wanted to make sure.
Okay. All right, Mr. Plummer, and that is position 29, and that is Ms. McLeod's client. And Ms. McLeod, are you ready? Maureen McLeod? Mr. Plummer, did you speak to Attorney Maureen McLeod?
Yes, ma'am. I just spoke with her.
All right, I'm just waiting for her to unmute and start her video.
Okay.
No. Miss Grace, can you contact Miss McLeod? I don't know why her Attorney McLeod is not responding. I don't know if she's having a technical issue.
Okay.
But we'll hold on jail court iPhone. Miss Kim, are you ready to proceed? No? Okay.
Well, we can go with position number 2, Mr. Denton.
Okay. Position number 2, and that is Quintavious Benton. Yeah. Whoever sent me that chat about Carrington Matthews, yeah, I know that. All right. Position number 2, and whose client is that? That's also Miss McLeod. Jail court iPhone, that's also Miss McLeod's client, and for some reason she's not responding.
Okay.
We are trying to reach out to her and see what the problem is. All right.
Currently, what's it?
But I'm getting sealed up.
Your Honor, Ms. McLeod is on the phone with one of her clients.
Okay, so courtroom 2, are you ready to proceed?
Yeah, we're ready with position number 30, Mr. Ransom, Travis Ransom.
We do have an announcement that he would like to reset the case to next Tuesday, Your Honor. There are a lot of things that we need to discuss more.
Okay, position number 30, Travis Ransom is reset to September 12th at 9 a.m. All right, courtroom 2, I can take another case.
Excuse me, Judge, what case number was that?
Position 30, Travis Ransom. And
For what's the date? 9/12, you said?
9/12. Next Thursday. And that will be also for position 31. Until we find out who is Mr. LeVar's private counsel.
So you don't have to remember
All right. Ms. Kim, are we ready to proceed?
We're done with Mr.
That's okay, I'll take the next case then.
Your Honor, we don't have any more cases ready as of yet in courtroom 2.
Okay.
Mr. Cloud was on the phone with one, and Mr. Ty, she's waiting for some information on the other.
Okay, then I'm going to my bench warrant calendar. Zoom user, again, what's your name, please?
Orlando Morrow.
Okay. Miss Grace, can we change the title on that Zoom panel to Orlando Morrow? Position number 2 on our bench warrant calendar. Mr. Morrow's case is 21 CR 004695B. Mr. Morrow is accused of simple battery, family violence, and theft by taking from July 29th, 2018. Mr. Morrow, you have a right to remain silent about the facts of the case. Anything you choose to say on this recorded and live stream proceeding, your statements can and will be used against you. You have a right to an attorney. If you cannot afford one, one would be appointed to represent you. Who is your attorney at the present time?
I do not have one, ma'am.
Okay. Have you conferred with the public defender's office?
No, ma'am.
Ms. Atay, did you have a comment?
Your Honor, is this the one that was reset from Tuesday? You have a private attorney, right? But they weren't there on Tuesday?
I wasn't here Tuesday, so. Mr. Morrow, were you here in court on Tuesday?
That was last week, Thursday.
I didn't see, I need to look. I have the other 2 bench warrant cases, Ms. Rosser and Mr. I don't know how to pronounce it, Rulet. But I need to look at this one and I'll call Mr. Morrow.
Yeah. Your Honor, just so I can kind of fill this in a little bit. This case was on the calendar last week. The defendant decided he wanted to enter a plea pro se. The PD's office then declined to represent him for that plea. The defendant's plea then did not move forward. And because the PD's office had already left, there was no one to then represent him on the bench warrant. And so the court reset the case so that we could address it today.
All right, thank you. Mr. Morrow, since your case reset from last Thursday, have you retained counsel?
I do not have nobody.
Okay.
I cannot afford no lawyer right now.
And did you speak to the public defenders? Oh, I'm sorry. And the public defender's office has decided not to represent you if you move forward with the plea. So that's the situation, Ms. Atay. Ms. Atay, would you like an opportunity to speak to Mr. Morrow?
Well, now I remember this one now. Okay, so that was Mr. White and he did, are you moving forward with a plea, Mr. Morrow?
See, be honest, I'm not trying to take no probation time because I ain't do none of that.
Okay, so I think that then Mr. White will need to reach out to you. This is what we wanted to do.
Mr. Morrow, you need to put your phone number in the chat on the Zoom and direct it only to room 2.
So now he wants to not plead guilty? Okay.
So the reason we are here today is because Mr. Morrow has a bench warrant that was issued by Judge Porter on February 16, 2024 for failure to register jury trial back in November 8, 2023. So that's the current status of the case. All right, so Mr. Morrow, please mute your screen and put your phone number so Attorney Tom White can speak with you.
I just did, ma'am.
All right, please mute your screen. Thank you. All right, medical, who do we have? Oh, sorry. Courtroom 2, who do we have seated next to you, Ms. Ate?
Oh, this is Ms. McLeod's client.
This is going to be the add-on calendar, Your Honor, Mr. Friedman.
And that's Ms. McLeod's client? Okay.
That's correct.
Attorney Maureen McLeod. Ah, there you are.
Your Honor.
Okay. Ms. McLeod, you have a couple of cases to address.
That is correct, Your
All right.
Honor.
Let's start with Mr. Plummer at Jail Court iPhone.
Yes, Your Honor.
Okay. And how are we proceeding with Franklin Plummer?
I'm going to be waiving arraignment for Mr. Plummer. And we're going to proceed. He wants to go to trial. He is not accepting the state's plea offer.
All right. Mr. Plummer, your case is 24 CR 5974G. You're accused of battery, family violence. You have a right to remain silent. Anything you say in open court, your statements can and will be used against you. Your attorney is Ms. McLeod. Your attorney is going to enter a not guilty plea on your behalf, and your case is going to be further notice for trial. Thank you.
Yes, and Your Honor, we would also like to see if we could get a reduction in his bond because he has a $5,000 cash bond.
Oh, okay. Let me go ahead and pull his case up. Okay, go ahead. You proceed. Ms. McLeod?
Yes, Your Honor. My client has a $5,000 cash bond, Your Honor. Of course, he's not in a position to pay that bond, so that is the reason why he's still sitting in jail. So I would ask the court to consider making that into a surety bond instead of a cash bond.
And you understand that he's got another open case, 20 CR 4860G.
Yes, Your
And Your
Honor, I
Honor,
understand that.
Okay.
And Your Honor, that involves the same victim,
Well,
which I believe is what contributed to the cash bond.
let's see now. And this was Tiffany White, and the alleged victim, the incident date in the 2024 case was June 12, 2024.
Yes, Your Honor.
Okay. And in 20 CR 4860G, the incident date was July 31st, 2020. And he was scheduled for a jury trial and he failed to appear. And his next court date is, oh no, he did appear for that trial, which was on February 1st, 2024, and consolidated the cases. And oh, looks like he's got a court date with Judge Mather on September 18th, 2024.
That is correct, Your Honor.
Okay.
So he did appear for that case.
But he didn't appear for trial in the 24 CR.
Well, I don't believe he had trial in that case scheduled. That was not my understanding.
Oh, no. Disregard what I just said. I'm getting to, I've got multiple windows open, so make sure I'm on the right one. Okay, no. He did appear for trial in the other case in February, and the case was reset, and now these two cases are consolidated, and he's got a court date before Judge Mather on September 18th. All right, just close out these other cases so I don't get confused. Okay. And this one was a $5,000 cash bond that was issued on August 24th because apparently this involved the same victim from an incident date of June 12, 2024. Why was I looking? Oh, yeah. And there's no order amending the contract provisions in the prior case. Okay. Ms. Falk, anything else to add?
Yes, Your Honor. He's also, and actually this is oversight of the state, which we will rectify immediately. The defendant is actually on felony probation under 21 SC 177895 for aggravated stalking, aggravated assault strangulation, aggravated assault family violence, 2 counts. And that was, again, same victim, Miss Tiffany White. And he is currently on 5 years probation with 1 year to serve that was sentenced on October 13th, 2021 by Judge Dunaway in the Fulton County Superior Court. That is the basis for this case being upgraded to a felony family violence battery, and we will rectify that immediately. We'll withdraw the recommendation and go forward to having this case upgraded to a felony. That's all for the state.
Anything else to add?
I'm not on probation for that anymore, ma'am.
I'm sorry?
I'm not on probation.
Probation is already finished on that case that Ms. Falk mentioned.
I just currently sat in here 11 months. In the 11 months that I just sat in here, I got out in April. 11 months I sat in here, they suspended that last year time 2 for 1 while I was sitting in here. I'm not on that probation anymore now.
Okay.
And Your Honor, that is correct. He entered a plea. His probation was revoked May 2nd of 2024. I just saw this order of revocation by Judge Dunaway. He was revoked for 1 year, and his probation was suspended, not terminated.
All right. Ms. McLeod, anything else?
Yes, Your Honor. I don't think that that is a reasonable bond, even based on what Ms. Falk says, because the 2020 case was a long time ago, and this case was something completely recent. So what the terms and conditions, he thought that the case was not open anymore. That is why they were having contact. And I just think that a $5,000 cash bond is essentially no bond for him. He just is not in a position to pay that. So that's just saying you have to sit in jail until your case comes up.
No. We don't require him to sit in jail. The bond is set reflective of the individual's GCIC conduct and likelihood to reoffend or not to appear in court. So I don't see it as staying in jail. I'm just trying to see whether the bond correctly reflects what is going on. So if you can tell me otherwise, I mean, if you think the bond does not reflect what's going on, I mean, I'm definitely will change it, but you tell me.
He did appear in court for his last court hearing, so he's not a risk not to appear. That is evident. He was in court in February on his case. His case schedule is aware that the case, the 2020 case, is scheduled. And of course, he will be appearing on the 18th of this month for his trial in that particular case. This is a misdemeanor after all. And a $5,000 cash bond seems excessive under the circumstances.
And Your Honor, I would disagree. I haven't even gotten to the fact that the defendant was convicted of robbery let's see, when was that? Because that was fairly recently. That was a conviction on August 12th of 2024 before the Fulton County Superior Court for 9 years probation, had a failure to appear on May 7th of 2024, has multiple probation violations going all the way up until March 28th of 2023. This defendant may not be, the defendant's a risk of reoffense, a risk of intimidation of the witness, since this is the same victim in the 21 SC case, the same victim in the 20 CR case, and is a risk of flight, being he recently had an FTA. Basically, he fails on every IALA factor we've got. And it's interesting that Ms. McLeod kind of overlooks the fact that he was under a felony sentence on 21 SC 177895 when he reoffended against the same victim.
All right. Mr. Plummer?
Yes, ma'am.
The cases that I have with me right now are from July 31st, 2020, where you were allegedly accused of battery family violence. That's the case I have. Then on November 7th, 2020, you were arrested again on felony charges involving Tiffany White. You were convicted of that case. You served your probation. That's over and done with. But the point is, that is a second violent case involving Tiffany White. Then, while you are under a no contact with Tiffany White, you get arrested again for a June 12, 2024 incident involving Tiffany White. This is boom, boom, boom. Tiffany White is not good for you and you are not good for her. And the $5,000 cash bond reflects the fact that you pose an imminent threat to Tiffany White.
Listen, ma'am, Your Honor. The victim who you are, Tiffany White, she's just recently, I had a TPO out on her. If you look at the address, she was where my address was. She didn't have no business being around me. And I understand everything you're saying, but if you look at her background, she's on probation for stabbing my mother. She stabbed me. That's why I caught the simple battery, because we both went to jail. And she's still out on bond for aggravated assault for stabbing me.
I've already said that Tiffany White is not good for you and you are not good for her. But right now, I'm just looking at your cases and the $5,000 cash bond stays. Thank you.
Thank you, Your Honor.
This case is going to trial. Thank you. Unless the state upgrades it to a felony.
We're working that up to send to the DA's office right now.
Please take a note that you all have a hearing with Judge Mather on September 18th. Okay?
That's correct.
Yeah. Jail court iPhone, who do we have?
This is another one of Mr. McLeod's clients, Mr. Benton, position number 2.
This is Quintavious Benton, accused of battery, simple battery, and willful obstruction of an officer from August 17th, 2024. Case 24 CR 5797G. Mr. Benton, you have a right to remain silent. Anything you choose to say in open court, your statements can and will be used against you. All right. Sheila Rosser, go to your closet and put on a shirt and take your hat off. All right. Stop her video and she needs to go put on a shirt. All right. As I was saying, Mr. Benton, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney if you cannot afford one. Ms. Maureen McLeod will be representing you. Ms. McLeod, how are we moving forward with Mr. Benton? I'm sorry, you're on mute, Ms. McLeod?
I need the state to say what its offer was because I was a little confused about that.
All right. Mr. Benton, this is a possible negotiated plea. May I place you on, well, I'll place you on the oath until we get the plea offer. Ms. Mokeke?
Yes, Your Honor. The state's recommendation for count 1, the battery, was 12 months served 90 days, credit for time served 19 days, no further contact with Rosalinda Rios, stay away from the Checkers located at 120 Piedmont Avenue, 12 weeks of anger management and MHET, and no firearms. For count 2, the simple battery, the state's recommendation was 12 months concurrent with count 1, no further contact with Essence Tyson. For count 3, the willful obstruction, the state's recommendation was 12 months concurrent with count 1, a $300 fine, and 40 hours of community service.
Ms. McLeod, are these the terms you communicated with your client?
I have not yet spoken to him, Your Honor. I'm sorry. I thought this was someone else, so I do need to speak to Mr. Benton.
All right.
Mr. Benton, yes.
Okay. Jail code iPhone, do we have any more cases at your location for Ms. McLeod?
Yeah, we have multiple people on the floor. We went back to grab a few more people.
Okay, so please hold, and Ms. McLeod will need to speak with Mr. Benton. I guess you'll be calling her, right?
Yeah.
Okay.
I also have Mr. Friedman, Your Honor.
Yeah.
I've already spoken with him.
Okay, courtroom 2, what's the gentleman's name?
Can we do position number 4 first, so I can take him back over to 3 North?
Okay, just yeah, who's in courtroom 2? Is that Ms. McLeod's client as well?
I believe it is Mr. Friedman.
Oh, that's Mr. Friedman. You need to talk to him as well?
No, I've already spoken with Mr. Friedman.
All right. Mr. Friedman is on deck. Medical, who do we have?
Position number 4.
4, okay. No. And that is Yilin Chen. Mr. Chen, do you speak English, sir?
I do, ma'am.
Thank you.
I do, Your Honor.
Ms. McLeod, is that your client?
It's my
No, Your
client.
Honor, it's not.
And,
Ms. Tate, okay,
Mr. Friedman is my client.
all right.
and it's a negotiated plea, Your Honor.
Okay, Mr. Friedman, okay, folks, just one second. Mr. Friedman's on deck. We're going to address Mr. Chen, and then Ms. McLeod is going to address Mr. Friedman, then speak to her client at Jailport iPhone. I'll try to keep all these in line. Okay. Mr. Mr. Chen, your case number is 24 CR 5919G. You are accused of criminal trespass and terroristic threats and acts, both misdemeanor charges. You have a right to remain silent about the facts of your case. Any statements you make during the course of this virtual proceeding, your statements can and will be used against you. You have a right to an attorney, and Ms. Oda Atay will be representing you. Ms. Atay, on position 4, this is going to be a possible negotiated plea. Has
Yes.
it, what's
Yes.
confirmed?
It's a negotiated plea, Your Honor.
Mr. Chen, please raise your right hand. Solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge.
I swear the information I provide will be the truth of my knowledge.
Thank you. Mokeke, what is the recommendation?
Yes, Your Honor. The state's recommendation for count 1, the criminal trespass, is 12 months to serve 28 days, credit for time served 14 days, balance probated, while on probation to stay away from 330 Capitol Avenue, Southeast Atlanta, 40 hours of community service, a BHET, and no firearms. Count 2, the terroristic threats, will be null crossed upon the plea. And I would ask the defense to stipulate to venue, factual basis, and identification for purposes of the plea.
All right.
We stipulate, Your Honor.
All right. Mr. Chen, have you consumed any medicine or alcohol recently?
Yes, I have consumed the lithium and
Just have to say yes to medicine or alcohol. You don't have to tell me what medication. That's
oh,
fine.
yes.
Okay. And after consuming the medicine, are you still able to understand the proceedings?
Somewhat.
Somewhat. Okay. If you don't understand the proceedings, then we have a problem, because I need to make sure that you understand that what you are pleading, what you're pleading to, and what is the disposition of the case. And I want to make sure that you're doing it freely, willingly, and knowingly. So if the medication is affecting you, I'll have to take your case later on.
No, it's not. I'm clear. I'm level-headed right now.
Okay. And were you able to understand your conversation with your attorney?
Yeah, I was.
Are you satisfied with your legal services?
I am.
And do you understand the charges brought against you? Criminal trespass at the Nathan Deal Judicial Center, which houses the appellate courts.
Yeah.
Do you understand those charges?
I do.
Okay. Are you entering this plea willingly, knowingly, and voluntarily?
Yes.
And do you understand that if you enter this plea, you would have to give up your constitutional right to a trial before a judge or a jury? You will not get the opportunity to go back to court, to confront your accusers, to challenge the evidence that we brought against you, to have the assistance of counsel so that you can present your defenses, arguments, and mitigating factors if you choose to do so, and also to have the prosecutor carry its burden to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yeah.
And you understand that you will not have a right to an appeal once I sentence you.
Understood.
How do you plead to 1 count of criminal trespass and 1 count of terroristic threats and acts?
Your Honor, the terroristic threats and acts is null crossed. It's just criminal trespass.
Ms. Mokeke?
Yes, that is correct, Your Honor. We are null crossing the terroristic
I'm
threats.
sorry, I thought it was the other way around. Sorry about that. Let me repeat my question. Mr. Chen, how do you plead to 1 count of criminal trespass?
Yeah, I feel okay.
How do you plead?
How do I plead? I plead guilty. I plead guilty.
On the criminal trespass, your sentence is 12 months to serve 28 days, credit for time served 14 days. The remainder of your time will be served on probation. While you're on probation, you will stay 200 yards away from 330 Capitol Avenue, Southeast Atlanta, which is the Nathan Deal Judicial Center. You're only allowed to enter that building in a peaceful manner and with no breach of peace if you have a case that involves you and it is docketed with any of the courts in that building. Do you understand?
Understood.
That is your only way you're allowed to enter the building while you're on probation. Otherwise, you have to stay away from that building. While on probation, you will complete 40 hours of voluntary community service with any nonprofit agency that's not a church and not a school. You will also undertake a behavioral health evaluation, and that must be done within 15 days with a qualified therapist or healthcare provider, and you must submit yourself to any treatment that's required. At no time are you allowed to own a firearm while you are on probation. Your probation report date is September 9th, 2024, before 3 p.m. at 132 Mitchell Street in downtown Atlanta, and you must report there promptly and report to probation once a month thereafter. Thank you.
Thanks.
Okay, next case, please. Jail Court iPhone, who do we have?
Yeah.
Position number 10, Mr. Jabrou.
Yes.
10. Okay. Is this Johannes Gebru?
That's you.
Yes, Judge, yes.
Mr. Gebru, your case is 24 CR 6088J. You're accused of criminal trespass from July 27, 2024. You have a right to remain silent. Anything you say in open court, your statements can and will be used against you in the treatment of your case.
Yes, Judge.
You have a right to an attorney. If you cannot afford one, Mr. Tom White is going to be representing you.
Your Honor?
Yeah.
I've tried to break in a little bit. I was told he was released yesterday. Obviously, that's not true, so I will need to speak with him.
Okay. After Mr. Gebru needs to speak to his attorney, Tom White, I do have a notation that he was released, but apparently that was incorrect. So please, do you call Mr. White or does Mr. White call you?
We're gonna try to call a courtroom.
Okay.
Yeah, that's
2060, go be 2060.
Okay.
We can do Ms. McLeod's case, Mr. Friedman.
Okay. Ms. McLeod, hope you're still here with us.
Yes, Your Honor, I am.
Right.
And he is on the add-on.
Okay, thank you.
Position 1 through 4.
Oh, sorry. Just give me a moment. There we are. Okay. This is State versus Darren Friedman. Mr. Friedman, you have 2 misdemeanor cases and 2 bench warrants. The misdemeanor cases are 24 CR 2249F, in which Mr. Friedman is accused.
Yeah, let me talk. They told me yesterday.
Criminal trespass from April 24th, 2024. Second case is 24 CR 3947F. In which he's accused, of criminal trespass as well from June 18, 2024.
I got it.
Mr. Friedman, you have 2 bench warrants in addition to the 2 open cases, and they are 24 FTA 1213 and 24 FTA 1214. You've been advised of your right to remain silent, and your attorney is Ms. McLeod. Ms. McLeod, how are we moving forward with this cases?
We would be requesting signature bonds for my client. He tells me that he had been in constant contact with the court regarding his court date. He had a good address with the court and everything, and he was looking forward to having his day in court because he absolutely denies that he is guilty in either of these two cases, Your Honor, and he does want a trial. I would note that the state's offer is essentially a time-served offer, but my client is not interested in accepting this offer. He does want to go to trial because he maintains that he is not guilty, Your Honor. He is not in a position to pay for any kind of bond on that. He tells me that he had bonded out on the initial cases, was looking forward to going to trial, and next thing he was picked up on an FTA, even though he had supplied the court with proper addresses for him to be contacted for a hearing. So that is the position that he takes, Your Honor. So I'm seeking signature bond release of my client so he can be out of jail, so he can properly prepare for defending against these charges.
Your Honor, I didn't wish to interrupt Ms. McLeod, and so I do want to ask, which positions are we discussing?
Oh, I'm sorry. This is the add-on calendar, positions 1 through 4. I assume they may have been reset from a previous SAP calendar. I do not know, but
they were reset from Tuesday, Your Honor.
I see. Okay. And so as soon as Ms. Falk has those cases in front of her?
Yes, I do now, Your Honor. I kept looking for Friedman on the calendar, and I'm like, why can't I find this individual?
He currently has a $6,000 surety bond for failure to appear in court on both these cases.
Okay. And what I just wanted to take a look at is what the basis of his, just take a look if I can really quickly. It looks like Mr. Friedman did not appear on his two cases. Just go through. Looks like his failure to appear dates back from August 6th, 2024, which was a motions calendar set by Judge Richardson. It was reset. He was in SAP on July 2nd of 2024, and then his case was reset. And it appears that that was the date he failed to appear on both of his criminal trespass cases. Let's see, that is correct. And just looking at the bond conditions that were set by Judge Morrow, it appears that when these bond conditions were set, he was given a $1,000 good bond with a stay away from Laurel Mill Drive and no contact with Octavio Velasquez. And on the second criminal trespass, it looks like his bond was set at, looks like that was ordered by Judge Mincy on April 25th of 2024 and was a $2,000 good bond with the same no further contact and a stay away order. So these were ordered on two separate dates. The first was April 25th of 2024. The second was then ordered on June 19th of 2024. It looks like since they both involved no further contact and a stay away order, it's clear that his second offense in June was a violation of his first offense in April, that he stay away from that address and have no further contact. And so there is the issue of the fact that he was in violation of his first bond with the second case, and also the issue that he failed to appear on either case when called to court just 1 month later by Judge Richardson. And I haven't heard a sufficient explanation for why he just did not come to court less than a month after he was released on his from SAP and reset to go to court on both of these cases in August.
Huh? Ms. McLeod?
My client maintains that he did not receive notice, and that is why he did not appear. He told me that he called the court every week to find out if he was on, if there were any appearances, and was told no.
Your Honor,
No,
my
that-
apologies.
when did we get information about the Laurel Mill Drive address?
Perhaps the clerk's office can assist me with that. I don't know when I'm not seeing when he filed that.
Miss Grace, do you have that information? When did we get the information about the Laurel Mill Drive address?
Let me check, Judge.
What I have, I'm curious to know, when was it added?
And we're talking about the 985 Laurel Mill Drive address, correct?
Okay.
The address that he was ordered to stay away from on 2 separate bond orders.
Yeah.
It looks like on his arrest, I'm looking at his arrest paperwork on April 24th, 2024, and the arrest location that was given on that paperwork was 985 Laurel Mill Drive, and that was the address on the warrant as well for
Correct.
the defendant.
So, Ms. McLeod, your client provided an address which he was required to from which he was required to stay away. So if notices went to the Laurel Mill Drive address, Mr. Friedman never updated us with a new address.
Correct, Judge. That address has been in the system since 2019.
He tells me that he called on a weekly basis to check to see whether or not he had any hearings scheduled.
Understood, but one of the conditions of the bond is to update the court with any changes in your mailing address, and he did not.
If I may say something.
So, anything else to add, McLeod?
To speak on that, Your Honor, as to his address.
Okay.
And Your Honor, I do want to add something. The motions hearing that the defendant failed to appear for in August was the state's emergency motion to revoke his bond and a motion for immediate arrest based on the fact that he had a new offense after being given a bond for the previous offense.
All right. Anything else, Ms. McLeod?
No, Your Honor. I just want to ask the court to consider giving him the opportunity to actually fight this case, because that is what he wants to do. He could take a plea today and get out, but he does not wish to do that because he maintains his innocence.
Understood, and that's his constitutional right. Mr. Friedman, you have a right to remain silent, and anything you say can and will be used against you. So my concern is that I'm not sure why we don't have your correct mailing address, but the only address we have on file for you is the one that you're not allowed to use.
The initial arrest, the bond did not say that I could not go back to my house. I was actually told that I could. The second day I was home, I called the public defender's office, and they told me that they were going to get a adjustment made so I could stay at home. I have not.
Listen very carefully now, so that you and I have no misunderstandings. You have 2 open cases involving the Laurel Mill Drive address. Do you understand?
I understand.
You are to stay 200 yards away from that location and have no contact with the individual in question. Do you understand?
Yes, sir.
Do you know who that individual is?
That's Octaviano Velasquez.
Yes.
I was told recently that it's Michael Velasquez.
I don't care what you were told recently. Listen now.
Yes, sir.
You are to stay 200 yards away from Velasquez and not communicate with this person in any way, form, or manner.
Yes, sir.
I don't want you to leave this jail and say, oh, somebody else told me something. I'm telling you on record who you're required to stay away from and where you're required to stay away from. Do you understand?
I do, Your Honor.
The Laurel Mill Drive address is incorrect because by law, you are required to stay away from that address. Do you understand?
Yes, Your Honor. I wish to move out.
The minute you cannot return to that address. From this moment onwards, since the prior orders, you are on notice. You cannot be within 2 football field lengths of that location.
Yes, Your Honor.
I don't care if you left your toothbrush in that house. You cannot return to get it. Do you understand?
Yes, sir.
You are required to come down to the clerk's office and provide a new mailing address in writing within 48 hours of being released. Do you understand?
Yes, sir.
If the 48 hours falls on a Saturday, that means on Monday morning, bright and early, you're supposed to be in the clerk's office giving us your new and mailing address in writing.
And
The bonds are amended for each case is going to be amended to a $1,250 surety bond. Your total bond is $2,500. And if you fail to comply with this court orders, if you fail to stay away and fail to have no contact with the victim, I don't have a problem putting no bond in both cases.
may I say something, please, Your Honor?
I would recommend that you speak to your attorney. Anything you say can and will be used against you.
Understood, understood. May I please say something?
Up to you, sir.
I have no intention on going back to that house. I wish to move out completely and not have anything to do with them. They have we have never had contact before. The initial bond did not say I could not go back to my house. It says something else. And I did stay away. I have not had any contact with them at all. The second arrest was because I was told that I could go back by a officer that went with me to get some of my property. I had no idea that
I will stop you right now. You've been incriminating yourself all this while. Share screen, please. May I have share screen? Is it enabled now? Okay, there we go.
Courtroom 2. Hey, Bill, what's up?
Do you see this bond order on the screen?
What? This is the new one. Yeah. Am I correct?
Correct.
Okay. Says Laurel Mill Drive. The first one said Laurel Mill Road, but I understand it's the same thing.
Okay.
I don't want to have anything to do with the house, but I don't have money for, the only money I have left over is for my new place. I don't have money for a bond. My sister's even helping.
$2,500 surety bond is your current bond. You would have to go through a bonding company. You don't have to pay the entire $2,500. It would have to be at least between 10 to 15% through a bonding company.
I wouldn't be able to afford a place to live then.
That's the ruling of the court. Thank you.
Thank you, Your Honor.
Thank you. Next case, please.
Mr. Benton?
Yeah, I'm not certain. Jail court iPhone, is that Mr. Benton?
Yes, position number 2, yes, Mr. Benton.
Ms. McLeod, you will need to submit a proposed order modifying Mr. Friedman's bond.
Yes, Your Honor.
Okay. Jail court iPhone, that's Quintavious Benton, correct?
Correct.
Okay. All right, and I've already allocated his case number. He's charged with battery, simple battery, and willful obstruction of an officer. Ms. McLeod, how would your client like to proceed?
This is going to be a negotiated plea, Your Honor.
Mr. Benton, if we could unmute jail court iPhone. Please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
Thank you. Ms. Mokeke?
Yes, Your Honor. The state's recommendation for count 1 battery is 12 months to serve 90 days, credit for time served 19 days, balance probated, no further contact with Rosalinda Rios, stay away from 120 Piedmont Avenue, 12 weeks of anger management and MHET, and no firearms. For count 2, the simple battery, the recommendation is 12 months concurrent with count 1, no further contact with Essence Tyson. For count 3, willful obstruction, the recommendation is 12 months concurrent with count 1, a $300 fine, and 40 hours of community service.
Ms. McLeod, are these the terms to which your client has accepted? And do you stipulate to the factual basis, venue, and ID?
Yes, Your Honor.
Mr. Benton, please unmute jail code item. Thank you. Mr. Benton, have you consumed any medicine or alcohol recently?
No.
And have you understood what's been going on in your case?
Understand?
Have you understood what is going on in your case?
No.
Okay. Do you still have any questions to ask of your attorney so that you can understand what's going on?
When do I get out?
Okay. Ms. McLeod, do you understand that what is going on right now, that you're pleading guilty to these charges and being sentenced to probation?
Yes.
So again, I'm going to ask you, after talking with your attorney, do you understand what is going on with your case?
No, I don't understand what's going on with the case.
What are you charged with? What are your charges?
I really don't know.
Ms. McLeod, I don't think your client has a
I agree with you, Your Honor. I did discuss all of that with him, but it seems that, and he's not going to get out today either. Under the terms of this. So we can put it off until next week. I'm fine with that. I will actually go down to the jail to have a talk with him.
Hey, excuse me. I didn't understand what she said. Well, why you say no?
Mr. Benton.
I understand what she said.
Mr. Benton, listen very carefully. Listen very, very carefully.
Yes.
You have a criminal case against you. Do you understand?
Yes.
If you decide to plead guilty today, you still have to stay in jail for about 26 more days. Do you understand?
Yes, I understand.
So I'm going to reset your case so that your attorney can have a very serious conversation with you. So the next time the judge asks you, do you understand what is going on? You will understand what is going on. Do you get it? Do you get it?
Yes.
I will see you next Thursday, September 12th at 9 a.m.
Okay.
Thank you.
Thank you, Your Honor.
Position number 27, Mr. Oscar Osborne.
Okay.
Your Honor, I believe that concludes my business before the court today.
You promised me, Mr. McLeod?
I believe so, Your Honor. But I do have to prepare my plea paperwork for Ms. Lewis.
All your other cases. Understood.
Yes, so I'm going to do
We know where
that.
to find you. We need you back. So
That is correct.
Thank you, Ms. McLeod. Yes, you're free
You're
to go.
welcome.
All right, Oscar Osborne. Oscar Osborne. Oscar?
He talking to you?
Your Honor, before.
Are you Oscar Osborne? Yes or no?
Yes, I am.
All right. Please turn yourself around and face the screen. So I can see you. Perfect. Thank you. Good morning, Mr. Osborne. My name is Judge Lal, and we are addressing your case 24 CR 5892Y, in which you are accused of theft by taking. Do you understand, sir?
Yes.
You understand, sir?
Yes.
You have a right to remain silent about the facts of the case. Anything you choose to say can and will be used against you. You have a right to an attorney, and your attorney this morning is Ms. Kim. Do you see Ms. Kim on the screen?
Right.
Do you see her? She's waving her hand at you.
Yeah.
Okay, that is your attorney, okay?
Yeah.
Okay. Ms. Kim, what are we doing today?
Actually, we would like to plead not guilty, waiver of arraignment.
Right.
Mr. Osborne, your attorney is entering a not guilty plea on your behalf. You understand, sir?
Yes.
And he will schedule your case for trial. Do you understand, sir?
Yes.
That concludes your case. Thank you. All right. Mr. White, have you spoken to your client?
I have, Judge.
And could you remind me of his position number?
10.
Thank you. And how would we like to proceed?
He'd like to accept the state's offer and enter a negotiated plea, Judge.
Mr. Gebru, please raise your right hand.
Yes, Judge.
Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
Thank you. Ms. Mokeke?
Yes, Your Honor, this is position 10.
Yes. Johannes Gebru.
I apologize for the background noise. The state's recommendation is 12 months to serve 20 days, credit for time served 10 days, balance suspended, and a stay away from the Quality Inn located at 6800 Studio Way, Union City.
Mr.
And
White?
we would ask the defense to stipulate to venue, factual basis, and identification.
Stipulate nothing further.
Mr. Gebru, have you consumed any medicine or alcohol?
No, Judge, no, I haven't.
And have you understood what's going on in your case?
Yes, I do understand.
Are you satisfied with your legal services?
Yes, I am.
And if you decide to plead guilty, you would have to give up your constitutional right to a trial. You will not have the chance to confront your accuser, challenge the evidence brought against you, present your own defenses and arguments, and have the state prove the charge beyond a reasonable doubt. Are you prepared to give up these rights?
Yeah, that's fine with me. That's fine with me, Judge. That's fine.
How do you plead to 1 count of criminal trespass?
I plead guilty, Judge. Guilty.
Your sentence is 12 months to serve 20 days, credit for time served 10 days, balance suspended. You are, your obligations for this case is over, but if you return to the Quality Inn at 6800 Studio Way in Union City, you will be arrested again.
Yes, Judge. Thank you.
Thank you.
Thank you, Your Honor. Also, briefly before we go on to the next, Mr. Morrow, who is on the DV calendar.
Mm-hmm.
All right, yes. So his case was reset, and I'm not sure why did it ended up getting reset, but he wanted to enter a plea that the state made an offer the last time. He does now want to accept that offer, and our position again is he's welcome to do so, but you can't represent him. So.
Your Honor, absolutely not. We made the offer last week. The defendant then started stating on the record that he was not guilty of the offense, that he didn't do anything. And so that's why the previous judge refused to go forward with the offer. At that point, we attempted to reach back out to the PD's office, but they had already left for the day. And so then this got reset to today. The defendant literally just came on the Zoom before he spoke to PD White and said he was not guilty. He didn't want to, but he just wanted to take a plea and be done with it, which Your Honor understands is not a knowing and voluntary plea. And so either Mr. White represents him and he's going to do this plea, or Mr. White represents him and we're going to address the bench warrant.
Mr. White?
With all due respect to Ms. Shelley, she can't force us to take a case, but.
And that is Ms. Falk. I have called you by your last name. I would appreciate if you do the same for me.
I'm sorry, I misspoke, Miss Falk. She can't force us to take a case, and he can take an Alford plea if he wants to, or what have you. I mean, people plead guilty all the time when they feel they're innocent. So, I mean, I don't understand her outrage.
Mr. White, does he qualify for the services of the Public Defender's Office?
I have no idea, Judge, but our office has told us that we're not represent anybody on a plea. I have no discovery on this case. I have know nothing about the facts. And it could be malpractice.
I agree. I agree. Thank you.
Thank
Mr.
you.
Orlando Morrow,
Yes, ma'am.
case was reset for you to either hire an attorney or choose to represent yourself. If you would like the services of an attorney, the public defender's office is at your disposal. You need to apply for their services and qualify for their services. And I agree that if you want to move forward with the plea offer, the public defender's office in all good conscience will not represent you because they have no information in which to advise you as to whether this is an appropriate decision on your behalf. And since you have also stated on record that you don't believe that you are guilty of the charge brought against you, I am rather leery of accepting a plea offer because my impression is that you want to take a plea just to get it over with, that you're not entering a plea freely, willingly, and knowingly. So the only question I'm going to address today is whether you go to jail or whether I'm going to set aside the bench warrant. Do you understand?
Yes, ma'am.
You want the services of the public defender's office to represent you on the request to set aside the bench warrant.
Yes, ma'am.
Jail court iPhone, please mute.
They're still trying to satisfy. Right. But she said, do you want to cut it off?
So what has he decided?
They won't take it, so we're just hearing for that.
Mr. White, we are addressing his motion to set aside the bench warrant. This is 21 CR 004-695B, State versus Orlando Bloom. And Mr. Bloom is accused of simple battery, family violence, and theft by taking involving one Sierra Telfair. Looks like he failed to appear before Judge Porter on February 16th, 2024. And looks like there was a notice sent to his prior address and it was returned to sender.
So he didn't get
Prior
notice?
address, was 314 Skipper Place in Northwest Atlanta. An apartment number was designated. And then he submitted a change of address on August 23rd, 2024, after his failure to appear. And his new address is a Humphrey Street location. So that's where we stand.
Okay, so he missed his court date and he did not actually receive notice, right? It was returned to sender, so.
That's not what I said. I'm just telling you.
You said it was returned to sender.
It was returned to sender based on a prior address provided.
Okay. So he did not receive notice. Obviously, the notice that was sent out was returned because he didn't receive it. That's how, that's how they get sent back. It's because he didn't receive it. So he did not receive notice to come to court for his last court date. That's not a dispute.
Ms. Falk?
And then I was staying with my sister at the time, and my sister wasn't giving me my mail.
What is your sister's address?
314 Skipper Place, apartment L is in Larry.
Apartment what?
L is in Larry.
Okay, thank you.
Which, Your Honor, is the address that was on the court notice that said return to sender, not deliverable as addressed, unable to forward. So that was the address he provided. The Postal Service was not able to deliver that address to the defendant. He did not update his address. He did not update his address until after it was returned. And so we would ask that the bench warrant remain as set.
It's like this house.
Can I say something, Your Honor?
One second. It is not, we don't know whose fault it was that it didn't get to him. If it was returned to sender, somebody at the post office decided that he couldn't deliver it. for whatever reason, but the addresses are the same. So that is not his fault. He did then, as soon as he figured out there was an issue, make sure there was an address that he could get mail on. So I don't think he should be punished for that.
He should not be punished for failure to update his mailing address
He did update his mailing address.
after the court date.
Okay. He was living with someone. That was the address. He was not getting his mail. Either it didn't get delivered, and then even on some occasions when his mail was delivered, there was somebody else there that he did not necessarily get it all. But it doesn't really matter. He never received notice. He did update his address. He could have received notice from that address if it had been delivered because he had family there, but it didn't go there. It didn't get delivered. Not that it's not a correct address. There is an address there. There are people that live there that are related to him. For some reason, the post office did not deliver it. Not his fault. And then he did, after that, change to give them another address where he's certain that he could get mail as well.
Okay.
So,
Miss,
sir, he's been on this Zoom call at least 2 times, which also shows that he's taking this seriously. He wants to go to court.
I understand, Mr. White. Thank you. Miss Tyson, if you are there, is pre-trial?
Yes, Your Honor.
Is there been any arrests since September of 2021? Just after September of 2021? Literally, what, 4 years ago? No, 3 years ago.
No, Your Honor, that was his last arrest.
All right. The request to set aside the bench warrant is granted. Mr. Morrow, you are under an obligation that every time you change your address, you are required to come down to the clerk's office in person and submit a change of address in writing. And that is to occur within 48 hours of your change of address. Do you understand?
Yes, ma'am.
All right. You are required to comply with the conditions of your original bond order, which involve no violent contact with Sierra Telfair, no illegal drugs, no alcohol, and no weapons and firearms. Do you understand?
Okay. Mm-hmm.
Okay.
You ain't even got to worry about that because I have personal.
Stop talking.
Yes, sir.
All right.
I don't know who Bro is, but as long as he understands, that's all I care about. Thank you. That concludes the case. Mr. White, can you submit the proposed orders and setting aside the bench warrant?
We can, Judge.
Thank you. And Mr. Morrow, your last instruction, either speak to the public defender's office to see if you qualify or go hire an attorney. Do you understand?
Okay.
The next time you
Yes,
show
ma'am.
up in court, you either decide that you have an attorney or you choose to waive your right to counsel and represent yourself. But right now, I'm putting you on notice that you need to take the steps to make sure that you have counsel if you want one.
Okay.
Thank you. You're free to go.
Mhm.
Who do
So
we?
I can hang up now?
Yes, you can hang up. Thank you.
Can we do position number 9, Mr. Joseph Edmond?
Okay.
Yes, Your Honor, I did email Ms. Falk about this. Yesterday, apparently, there is a $1,000 bond added in a 17 CR case. He did wish to enter, and at this point, it would be a negotiated plea, but he would not be able to be released to his Cobb County hold with this new charge that I just found out about.
So I was made aware of the new charge today. I am looking into it. So if we could just have a little bit more time for me to figure out what the 17 SCR case is. It looks like a theft by receiving, but I haven't been able to look into it more deeply to figure out what the recommendation would be.
Thank you.
Let me see. This is, so are we going to move forward with this plea today or what do we do?
We would like to attempt to, Your Honor. Again, I was just notified that there was another case that I was unaware of that is also holding this defendant that I believe PD Atai is looking for a global resolution to try to move both cases simultaneously.
What's the other case number?
It's 17 CR 025714B. And that was just added yesterday, that $1,000 bond.
Okay, all right. I guess we'll hold up. Are we taking a plea on the current case then? Because we can't do it unless there's a global offer. So we're going to put a hold on Mr. Edmond and take the next case. What's the next case, Deputy?
Yeah, we can go to, jail courts, iPhone or medical.
Thank you. Jail court iPhone, who do we have?
Section number 5, Mr. Cody.
Okay. This is State versus Terrence Cody, 24 CR 5956D, charged with 2 counts, a simple battery from August 23rd, 2024. Mr. Cody, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is Ms. Atai. Ms. Atai, is this a negotiated plea?
Your Honor, it is, sorry. It is a time served offer. So
with
yes,
probation.
Sorry, yes. This is going to be a negotiated plea.
Okay. Mr. Cody, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Ms. Mokeke?
Yes, Your Honor. For Mr. Terrence Cody, the state's recommendation for count 1 is 12 months to serve 28 days, credit for time served 14 days, balance to be probated, no further contact with Beulah White, stay away from 3601 Piedmont Road, Northeast Atlanta, 12 weeks of anger management, 40 hours of community service, and no firearms. For count 2, the simple battery will merge into count 1.
Ms. Ate, does your client accept these terms, and do you stipulate to the factual basis, venue, and ID?
Yes, Your Honor, we stipulate.
Mr. Cody, have you consumed any medicine or alcohol?
I can't hear you, ma'am.
Have you consumed any medicine or alcohol recently?
No, ma'am.
Have you understood what's going on in your case?
Yes, ma'am.
Are you satisfied with your attorney?
Yes, ma'am.
And are you entering this plea freely, willingly, and knowingly?
Yes, ma'am.
If you decide to plead guilty, you would have to give up your right to a trial. You will not be able to confront your accuser, challenge the evidence brought against you, present your own defenses and arguments, and have the state prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to 2 counts of simple battery? I'm sorry, 1 count of simple battery.
Guilty, ma'am.
Your sentence is 12 months to serve 28 days, credit for time served 14 days. Your jail time is concluded. However, you will serve the rest of the year on probation. You will report to probation on Monday, September 9th before 3 p.m. The probation office is at 132 Mitchell Street in downtown Atlanta. While on probation, you will stay away from 3601 Piedmont Road in Northeast Atlanta. You will stay 200 yards away from Beulah White and not communicate with her in any way, form, or manner. You are also to enroll in 12 weeks of anger management classes. Those are once a week, so 12 anger management classes, and you must do so within 45 days of being released. You're also to complete 40 hours of community service at any nonprofit agency, which cannot be a church and cannot be a school. You must begin with 5 hours in the first 30 days and a minimum of 5 hours every month thereafter. You're not to possess and own any firearms while you're on probation. Count 2 will merge with count 1. Any questions, Ms.
I'm sorry, can I request the waiver of the probation fees? He's on felony probation, and this would be an additional $49 a month that he would have to pay for this probation too.
All right, I will waive probation fees for the first 3 months. And I believe probation only charges him 1 time. So if he has concurrent probation, there should not be 2 separate probation fees, unless it's in a different county.
It's in this county, but I didn't run concurrent. Okay, but thank you.
All right, that concludes the case.
Position number 33, Patrick Rogers.
And PD, Ty, if you could check your email, I sent you an email on Mr. Eatman's case.
Thank you. 33 is Patrick Quentin Rogers. Would that be correct, Ms. Falk?
Yes, Your Honor.
Mr. Rogers' case is 24 CR 59308, accused of disorderly conduct.
We're not gonna stop.
Video called iPhone. Maybe you might want to stop the video while he's grooming himself. Okay, thank you. All right, Patrick Rogers, case 24 CR 59308, accused of disorderly conduct and public drunk from August 20th, 2024. Mr. Rogers, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney if you cannot afford one. We appoint a representative, and you are represented by Ms. Kim. Ms. Kim, will this be a plea offer today?
Yes, Your Honor.
Okay. Mr. Rogers, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am, Your Honor.
Thank you, sir. Ms. Folks, what is the recommendation?
Yes, Your Honor. The state's recommendation on this case is 12 months, serve 30 days, serve 15 days from August 22nd, 2024 until today. Balance suspended. Stay away from the Circle K located at 1337 Virginia Avenue in East Point. No further contact with Latrice Foster. Count 2 is time served, 30 days, credit for time served, 15 days from August 22nd, 2024. We would like to sound for Ms. Latrice Foster, and we do ask the defense to stipulate to venue factual verification for the purposes of this plea. That's all for the state.
All right. I don't see Ms. Foster on Zoom. Ms. Kim, do you stipulate?
Yes, Your Honor.
Mr. Rogers, have you consumed any medicine or alcohol?
How recently are we talking about?
48 hours?
48 hours. Well, I
You
was
don't
in
have to
case a couple of days ago, but no alcohol. No.
Okay. Are you still able to understand what's going on in your case?
Yes, as long as I can hear and understand what is being said. A lot of the stuff was just said. I couldn't hear it. I missed a lot of it. It went on, I couldn't hear it. But as long as I can hear it.
Stop me if you cannot hear what I'm saying, okay?
Okay. Yes,
Did
ma'am.
you hear what the prosecutor said?
Some of it, not all of it.
The prosecutor has indicated that if you decide to plead guilty, it would be 12 months to serve 30 days, credit for time served 15 days, which means that your jail time will be over. There will not be any probation. The balance is suspended, but you cannot return to the Circle K gas station at 1337 Virginia Avenue in East Point, and you cannot have any contact with Latrice Foster.
Okay.
Did you hear that?
Yes, ma'am, I heard that.
And for the public drunk charge, the sentence would be to serve 30 days, credit for time served 15 days, and that would be concluded today.
Okay.
Did you hear that?
Okay, yeah. So in other words, I'm done. I'm finished with. I'm time served, right, on both charges.
Correct.
Okay.
But
Okay.
you cannot return to Circle K, and you have to stay away from Latrice Foster.
Yes, ma'am. I will do that. No problem.
So those were the terms the prosecutor had offered, and your attorney had agreed that the venue, the identity of the defendant, and the factual basis are all true and correct. Did you hear that part?
Yes, I think I heard that.
All right. So now, so do you understand what's going on in your case?
Yes, ma'am. As far as I know, the charges have been, well, in other words, I got time served, so I'll be leaving today and just
In
stay
other
away
words-
from Circle K, stay away from Circle K, and stay away from Latrice Foster, right?
You will be pleading guilty to these charges. They will go on your criminal history record. And yes, you have no further obligations for this case other than to stay away and no contact. That's what's going on.
Yes, ma'am. Okay.
If you decide to plead guilty, would you be doing so freely, willingly, and knowingly?
Oh, absolutely.
Has it been explained to you that you would have to give up your right to a trial in front of a judge or a jury? You
Yes,
will not get a chance to confront your accuser. You will not be able to challenge the evidence brought against you. You will not be able to present your defenses and arguments, and to have the state prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to disorderly conduct and public drunk?
I plead guilty, Your Honor.
On the disorderly conduct is 12 months to serve 30 days. Credit for time served 15 days, balance suspended. No contact with Latrice Foster and stay away from the Circle K in question. For the public drunk is to serve 30 days, credit for time served 15 days, time served. That concludes your case.
Thank you very much, Your Honor.
Thank you, sir. Moving on to jail court iPhone, who do we have?
We have position number 32, Mr. Rhodes.
This is Dayan Rhodes, 24 CR 5969J, accused of theft by taking. Mr. Rhodes, you have a right to remain silent and stay in open court. Your statements can and will be used against you. You have a right to an attorney, and representing you is Ms. Kim. You have an additional case, 23 CR 5817J, in which you were accused of criminal trespass and transmitting a false report of a fire. How are we proceeding, Ms. Kim?
Negotiated plea, Your Honor. He pleads guilty.
Mr. Rhodes, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Ms. Falk?
Yes, Your Honor. As to the theft by taking, the state's recommendation is 12 months served, 26 days, credit for time served, 13 days from August 23rd, 2024. Balance probated, stay away from the Georgia State University property, no further contact with Rejoice Jones, anti-theft course, and 40 hours of community service. As to the add-on case, the criminal trespass would be 12 months served, 6 days, credit for time served, 3 days, from September 27th to September 29th of 2023. Balance suspended, stay away from the Georgia Tech property, and on the transmitting false report of a fire, time served, 6 days, credit for time served, 3 days, from September 27th to September 29th of 2023. We would like to say that Mr. Joyce Jones does agree with the plea offer. She will not be on the Zoom but we would like to sound for her out of an abundance of caution, and we would ask the defense to stipulate to venue, factual basis, and identification for the purposes of the plea. It looks like the defendant has his hand up and may have a question that he needs to address with PD Kim, and the state has nothing further.
All right. Mr. Jones, Mr. Rhodes, do you have a question?
Yes, ma'am.
Ask me, you can call me at the courtroom too, and I'll talk to you. Unless it is.
Do you have a question about the
It's more like it's more like with the judge, but like I got a problem with Georgia Tech because they had took all my belongings and told me not to come. They gave me a slip talking about I can go get my stuff, but they was like I can't be around there. So I was like, all right, I'll come get my stuff. So once I tried to come get my stuff by myself, they actually had put me in handcuffs and brought me here. And it was like a couple of months, like when summer had started. So when I was trying to get my stuff back, they had brought me here, and then they took me to Grady. You feel what I'm saying? Because they ain't want to take me here.
Mr. Rhodes, you need to speak to your attorney about what you're asking.
Yes.
It's like you want to dispute the allegations of I'm not sure, the criminal trespass at Georgia Tech. So, Ms. Kim, do you want to make yourself available to speak with him?
Yes.
They got my phone, my clothes.
Wait. You need to speak to your attorney so that she can ask the court what you are asking for, okay?
Yes, ma'am.
Okay. Quorum 2, do we have another case?
We can go back to position number 9, Mr. Joseph Itman.
Okay, and then we will go to medical. Miss Kim?
Yes, Your Honor.
Airport iPhone, can you call the courtroom 2 so that he can speak to Miss Kim?
Okay.
26.
Appreciate it, thank you.
Position number 26, O'Connor.
All right, medical will be right with you. Courtroom 2, Ms. Ate, your client is Mr. Edmond, is that correct?
Yes, Your Honor. And we are going with a negotiated plea and Ms. Falk, that I saw your email. When do you think that case, that null pros will be filed so that he can be released to the Cobb County hold?
I have already sent the email to Deputy Majeski in the DA's office. I hope to hear from him before the end of this court hearing. However, if we do not hear from him by the end of court today, I will reach out to him by phone to ask him to go ahead and file that by the end of the day. I did express to him that he was entering a plea as to his remaining charges, so that time was a little bit of the essence here so that he could be released.
Thank you very much. And so we're moving forward, Your Honor, with a negotiated plea.
This is State versus Joseph Edmond, 24 CR 6084E, in which he's accused of willful obstruction of a police officer, driving while license suspended or revoked, and attempting to misrepresent an automobile tag. Mr. Edmond, you've been advised of your rights, and your attorney is Ms. Ate. Please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
Ms. Mokeke?
Yes, Your Honor. The state's recommendation for count 1 is 12 months served 20 days, credit for time served 10 days, balance probated, 40 hours of community service, and a $300 fine. For count 2, the state's recommendation is 12 months concurrent with count 1 and a $500 fine. For count 3, the state's recommendation is time served 20 days, credit for time served 10 days. And we would ask defense to stipulate to venue, factual basis, and identification.
We stipulate, Your Honor.
I'm sorry, what did you say? Mr. Edmond, have you consumed any medicine or alcohol?
No, ma'am.
Have you understood what's going on in this particular case involving a traffic incident from April 26, 2023?
Yes, ma'am.
And are you satisfied with your legal services?
Yes.
Are you entering this plea freely, willingly, and knowingly?
Yes, ma'am.
So one of the charges brought against you is for driving while license suspended and or revoked. By entering this guilty plea today, this will trigger another suspension with the Department of Driver Services, and you will not be allowed to drive until the department allows you to apply for a reinstatement. Do you understand that?
Yes.
Are you still willing to move forward with this plea?
You have a conviction for that in the last 5 years?
We can ask Ms. Tyson. Ms. Tyson, this is Joseph Edmond on position 9. Or Ms. Mokeke, if you have his driving history.
I don't have a driving history. I can look and see if there's anything on his criminal
In the
history.
last 5 years, pleading guilty to or NOLO to driving while license suspended or revoked.
Yes, it was a 2022 where he pled guilty to driving. Well, I don't know if he pled guilty, but he was found guilty to driving while license suspended or revoked in 2022.
Your Honor, if he didn't plead NOLO at that time, can he enter a NOLO plea this time?
I believe, I may be wrong, but Sheila Rosser, please mute your screen. Okay. Any objection to accepting a NOLO contendere on driving while license suspended?
Let me think on that.
I mean, maybe I can help. If it's not good, then the department won't recognize it. So, I mean, They'll just treat it as a guilty conviction anyway, so. it doesn't-
Mr. White is correct. If the nolo contendere plea is not accepted by the Department of Driver Services, they will just sua sponte amend it to a guilty plea or treat it as a guilty plea, and his license will be suspended.
Okay, that is fine, Your Honor. No objection to the NOLO.
Okay. Ms. Tay, is that how we are proceeding?
Yes, Your Honor.
Now, I'm not certain because this is his second suspended license within the last 5 years. So I don't know if the department is going to keep the suspension in place. So you are proceeding at your own risk. I'm not the Department of Driver Services. I cannot advise you accordingly. All right. Given that information, Mr. Edmond, would you still like to move forward with this plea?
Yes, ma'am.
If you decide to plead to these charges, you would have to give up your constitutional right to a trial. You would not be able to confront your accuser, challenge the evidence presented against you during the course of a trial, and have the state prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to willful obstruction of a law enforcement officer?
Guilty.
How do you plead to misrepresenting a tag?
Guilty.
How do you plead to driving while license suspended or revoked on April 26, 2023?
No, Lord.
Your sentence for the willful obstruction is going to be 12 months to serve 20 days, credit for time served 10 days. Once you have resolved all your cases, you are required to report to the Fulton County Probation upon your release immediately within 48 hours of release, as long as it falls on a Monday, Tuesday, or Thursday. You must report before 3 p.m. at 132 Mitchell Street in downtown Atlanta. While you're on probation, you will complete 40 hours of voluntary community service that must be done with a nonprofit agency that's not a church and not a school. And you must begin with 5 hours in the first 30 days and a minimum of 5 hours every month thereafter. You will report to probation every month, once a month. And you will pay a $300 fine for willful obstruction with a minimum payment of at least $50 the first month and $50 every month thereafter. On the driving while license suspended or revoked, I'll accept your nolo contendere plea, subject to any changes by the Department of Driver Services. The sentence is 12 months concurrent with count 1 and a $500 fine. You will make your fine payments with a minimum of $50 per month and $50 every month thereafter. On misrepresenting a tag, your sentence is time served to serve 20 days, credit for time served 10 days.
And Your Honor, can we waive some of the probation fees, at least 3 months of the probation fees? He has all these other fines to pay. And can he report by phone after the first month so that, because in case he can't drive?
I will waive probation fees for the first 3 months, and he's required to report once a month. He can use public transportation or find a friend to bring him there. But he must report in person. And no driving unless the Department of Driver Services provides him with a valid driver's license, he has adequate insurance and proper registration. In other words, the correct tag and license plate on the correct vehicle. Thank you.
Position number 26.
Is that at medical?
Yes.
All right. This is State versus Julian O'Connor. Mr. O'Connor, if you please stay straight because the lighting is pretty dim. Thank you very much. Your case number is 24 CR 6087E, in which you're accused of criminal trespass and public drunk from August 27, 2024. Mr. O'Connor, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney in representing you is position 26. That would be Mr. White or Miss Kim? Mr. White, that's your client at the medical?
What was the name, Your Honor?
Julian O'Connor?
Yeah, yes, ma'am.
That's fine, Judge.
All right, and it looks like Julian O'Connor is having a negotiated plea. So, Mr. O'Connor, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Ms. Polk?
Yes, Your Honor. The state's recommendation as to count one, the criminal trespass, is 12 months to serve 20 days, credit for time served 10 days. From August 27th, 2024 to today, balance suspended. Stay away from the Quick Trip located at 4745 State Route 138 in Union City. As to count two, the public drunk, the recommendation is time served 20 days, credit for time served 10 days. From August 27th, 2024 until today. We do ask the defense to stipulate to venue factual basis and identification for the purposes of the plea. State has nothing further to present.
Stipulate, Your Honor, nothing further.
Mr. O'Connor, have you consumed any medicine or alcohol?
No, other than Biktarvy, Your Honor.
All right.
Yes, I know.
You don't have to tell me the medicine, but are you able to understand what's going on in your case so far?
Yes, Your Honor.
And are you satisfied with your legal services?
Yes, Your Honor, I am.
Good. Mr. O'Connor, if you decide to plead guilty to these charges, you would have to give up your constitutional right to a trial. You will not get a chance to confront your accuser, challenge the evidence brought against you, and have the state prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, Your Honor.
How do you plead to one count of criminal trespass at a Quick Trip gas station?
Guilty.
How do you plead to public drunk?
Guilty.
Your sentence for the trespass is 12 months to serve 20 days, credit for time served 10 days, balance suspended. Do not return to the Quick Trip gas station at 4745 State Route 138 in Union City. Otherwise, they will arrest you again and have you brought back to jail. On the public drunk, your sentence is to serve 20 days, credit for time served 10 days, time served. Your obligations for this case is concluded. Thank you.
Thank you, Your Honor.
Jail court iPhone, we're going back to
Position number 32.
32, thank you.
Your Honor, if before we address position number 32, is PD Atai available?
Yeah, I am.
PD Atai, I just wanted to let you know that the DA's office has responded to my email and they are working on it for Mr. Eatman's case.
Thank you very much, Ms. Paul.
Not a problem.
All right. So, Miss Kim representing Mr.
PD Kim was representing Mr. Rhodes.
All right. Now, Ms. Kim, is your client still willing to accept the proposed offer to stay away from Georgia Tech property and to stay away from Georgia State University property?
Yes, Your Honor.
All right. So, Ms. Rhodes, again, have you consumed any medicine or alcohol recently? Have you, in your conversations with your attorney, have you understood what's going on in your cases?
Yes, ma'am.
And are you still prepared to move forward with this plea?
Yep.
Mr. Rhodes, are you satisfied with your legal services?
Yes, ma'am.
And are you entering a guilty plea freely, willingly, and knowingly?
Yes.
If you decide to enter such a plea, you would have to give up your constitutional right to a trial in both cases. You will not get a chance to go back to court, to confront your accuser, challenge the evidence that we brought against you, and have the prosecutor prove the charges against you beyond a reasonable doubt. Are you prepared to waive these rights?
I already know
Are you prepared to give up these rights?
that. Yes, ma'am. Yes. I know I messed up.
How do you plead to one count of theft by taking on August 23rd, 2024?
You said what?
How do you plead to one count of theft by taking?
Yes.
Your sentence is 12 months to serve 26 days, credit for time served 13 days, balance probated. You will report to probation on Monday, September 9th before 3 p.m. And probation is located at 132 Mitchell Street in downtown Atlanta. While you're on probation, you're to stay away and cannot enter any property belonging to the Georgia State University. You are to have no contact with Rejoice Jones. You are to enroll in an anti-theft class within 45 days from today. And you are to complete 40 hours of community service with a minimum of 5 hours per month. How do you plead to 1 count of criminal trespass and 1 count of transmitting a false report of a fire in case 23 CR 5817J? All right, put that paper down and put the hand pen down. Now, put it down. Now. I need your complete attention.
I'm listening. I'm writing down what you're saying.
What did you just call me? What did you just call me?
I didn't call you nothing, ma'am. I said I'm writing.
Pay attention and stop writing.
I'm writing down.
Good. In your second case, 23 CR 005-817J, how do you plead? To criminal trespass?
Bro, she really just messed up, bro. From that, I ain't said nothing disrespectful to her. She messed up.
Deputy will take the case up on September 12th. Reset to September 12th.
Okay. She done still, bro.
Thank you,
I ain't said nothing to her.
Ms. Kim, Mr. Rhodes needs to understand how to pay attention, and we'll take his case up on September 12th.
Yes, Your Honor.
Next case, please.
Yep.
Courtroom 2, do we have any other cases? No? Okay. Moving on to jail court iPhone, we have another case.
Yeah, we have position number 1, Mr. Anderson.
Number 1, okay. Is that DeAndre Anderson?
Yes, ma'am.
All right. Mr. Anderson, your case number is 24 CR 6090F, in which you're accused of battery and theft by shoplifting from July 5th, 2024. You have a right to remain silent. Anything you say about your case, your statements can and will be used against you. You have a right to an attorney, and representing you is Ms. Atay. Ms. Atay, on position number 1, I understand your client's entering a not guilty plea?
Yes. And I'll file a waiver of arraignment.
Okay. Mr. Anderson, your attorney, Ms. Atay, will be entering a not guilty on your behalf, and your case will be further noticed for trial. Anything else? Not you, your attorney. Ms. Atay, anything else?
Nothing further.
All right. Mr. Anderson, if you have any questions, please reach out to your attorney. Thank you. Jail court iPhone, do you have another case?
Yes, position 34 and 35, Mr. Thompson.
34 and 35.
Antoine Thompson.
Yes.
Yes, Your Honor. He is my client, Your Honor.
Okay. Antoine Joseph Thompson has got a case 19 CR 8790F, in which he's accused of violations of a pedestrian and roadway, carrying a weapon without a valid license, and carrying a concealed weapon. Position 35 is a bench warrant, 24 FTA 1184. Mr. Thompson, you have a right to remain silent. Anything you say about your cases, your statements can and will be used against you. You have a right to an attorney, and representing you is Ms. Kim. And this is going to be a negotiated plea. Mr. Thompson, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, I do.
Thank you. Ms. Fong?
Yes, Your Honor. The state's recommendation on this is on count 1, time served, 76 days, credit for time served, 38 days. That's going to be from October 24th to October 15th of 2019 and August 22nd, 2024 until today. Count 2 and count 3, due to the change in the law and the fact that he did not have any restrictions on him at the time that would not have allowed him to carry a concealed weapon, we are null crossing those 2 counts. Position 35, which is the FTA, the state is entering a null cross. We do ask the defense to stipulate to venue, factual basis, and identification for the purposes of this plea. That's all for the state.
Ms. Kemp, do you so stipulate?
Yes, we do, Your Honor.
Mr. Thompson, have you consumed any medicine or alcohol recently?
No, I don't drink alcohol.
Okay. Have you consumed any medicine?
No, ma'am.
And have you understood what's going on in your case?
Yes.
And are you satisfied with your legal services?
Yes, I am.
If you decide to plead guilty to violations of rules regarding pedestrian and roadway, you would have to give up your constitutional right to a trial in front of a judge or a jury, to be able to confront your accuser and have the state carry its burden to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, I am.
How do you plead to 1 count of pedestrian and roadway?
Yes.
Your sentence is 76 days, credit for time served 38 days. And that concludes your sentence. Your case is closed.
Thank you, ma'am. Thank y'all so much.
All right.
I go home today?
If you have no other cases, yes, you'll be released within 24 hours.
Yes, ma'am. I don't have any other cases.
Okay. Best of luck.
Thank you.
Counts 2 and 3 are null crossed and the bench warrant is null crossed.
Next we have position number 15, Mr. Henderson.
I'm sorry, Judge, how many days was on that last case?
76 days, credit for time served 38 days.
Thank you.
Number 15 is Christopher Henderson.
Yes, ma'am.
Represented by Mr. White.
Good morning, Mr. White.
Right. All right, Mr. Henderson, my name is Judge Lal, and we are going to proceed with your case 24 CR 005925F, in which you are accused of giving false information to an officer and criminal trespass. You have a right to remain silent about the facts of the case. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is Mr. Tom White. This is going to be a negotiated plea, I believe.
It is, Judge.
Okay. And Mr. White, I'm sorry, not Mr. White, Mr. Henderson, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Ms. Mulcahy?
Yes, Your Honor. For count 1, giving false information, that is going to be time served 28 days, credit for time served 14 days. For count 2, criminal trespass, that is going to be 12 months to serve 28 days, credit for time served 14 days, balance suspended, and a stay away from the Kroger located at 590 Cascade Avenue in Atlanta. I would ask the defense to stipulate to venue, factual basis, and identification.
We stipulate. Mr. Anderson, you can put your hand down now.
Mr. Henderson, have you consumed any medicine or alcohol?
Ma'am?
Have you consumed any medicine or alcohol recently?
No, ma'am. No, ma'am.
And have you understood what's going on in your case?
I do.
Are you satisfied with your attorney?
I am.
Has it been explained to you that if you plead guilty to these charges, you would have to give up your constitutional right to a trial, to confront your accuser, challenge the evidence in a court of law, present your defenses and arguments, and have the state prove the charges against you beyond a reasonable doubt? Are you prepared to give up these rights?
Yes.
How do you plead to giving false information to an officer and criminal trespass at a Kroger?
Guilty, Your Honor.
On the false information, your sentence is to serve 28 days, credit for time served 14 days. That's the time served. And on the criminal trespass is 12 months to serve 28 days, credit for time served 14 days, balance suspended. Your case is now closed, but you cannot return to the Kroger at 590 Cascade Avenue in Atlanta, Georgia. Otherwise, you'll be arrested again.
I understand, Your Honor.
Thank you.
Thank you.
Jail Court iPhone, do we have another case?
Officer. He's coming, Your Honor.
Thank you. Yes, Mr. Droulet, I do see you're there. I just need to complete my jail cases before I proceed to yours.
Go back and say no.
All right. I guess no jail cases at the present time, so we'll address State versus Rodre Droulet. Mr. Droulet, you need to stop walking around and have a seat.
Yes, ma'am. I'm about to have a seat. Yes, ma'am. Sorry.
Okay. This is case 24 CR 1018A on our bench warrant calendar. Mr. Droulet is accused of simple battery family violence from March 4th, 2024. He had an initial appearance on March 5th, 2024, in which he was given a signature bond. He apparently failed to appear in court on August 19th, 2024 before Judge Roth, and his bond was forfeited. He's got an outstanding bench warrant. Mr. Droulet, you have a right to remain silent about the facts of your case. Any statements you make can and will be used against you. You have a right to an attorney, and I'm assuming Ms. Atay, you are representing him?
Yes, Your Honor.
Okay. In addition to the present case, he has two other outstanding cases, 23 CR 2883H and 23 CR 5995D. Let me see what's going on. They should all be designated to. All right, looks like his bench warrant was voided on August 28, 2024 in the DUI case. Oh dear. And in the
Your Honor, are you looking at the 23 CR 005995 case?
now I'm looking at that, and
okay. I don't see any, if it may assist the court, I don't see any bench warrant on that case, just
No.
a case management order that was filed in May.
Correct, and he's got a plea hearing on September 24th, 2024. You might want to be writing this down. He's
Yes,
got
ma'am. I have it.
a hearing on September 24th at 1:30 p.m. before Judge Edline, along with the current case 24 CR 10188. All right. Yes, Ms. Atay, how would you like to proceed?
Yes, I'm making a motion to lift the bench warrant, Your Honor. He did have the failure to appear on August 19th, 2024. He did appear on July 2nd, 2024. He did not know about the hearing on August 19th, but he does have a good address, 470 Box Elder Road. And has been reporting to pretrial regularly. He does work full-time at GE Energy. He has 2 children, a 3-year-old and a 1-year-old. He's lived in Georgia for 17 years. He does intend to return to court. And he knows about the hearing on September 24th, Your Honor.
All right. Ms. Folk?
Your Honor, I just have one question for pretrial services. Has he been reporting regularly to pretrial services on this case? If pretrial services is there, Ms. Tyson?
It's nice to see you.
Yes.
Yes,
So
he
he's reporting to pretrial on, let's see, give me a second.
The defendant has one cycle, this is last arrest of May 20th of this year from Atlanta, for aggravated assault. The case is open.
I'm sorry. Oh, that somebody else?
Oh, it's just background noise, Your Honor.
Yeah, it's a little background noise. I'm sorry.
Charges restricted compensation.
Yep, it looks like he's there important as instructed, Your Honor.
Okay.
State doesn't have an objection to lifting the bench warrant, Your Honor.
Okay. Mr. Tate, please submit an order setting aside the bench warrant. It looks like all cases are going to be addressed by Judge Edline on September 24th, 2024. Mr. Droulet, I'm going to set aside the bench warrant, but it'll only go into place once the order is filed. So I highly recommend that you conduct yourself accordingly for the next 48 to 72 hours until the order is uploaded to the GCIC. Otherwise, if you get pulled over for speeding or anything like that, you could be arrested.
Yes, ma'am.
All right. You make sure on September 24th, when you appear before Judge Edline at 1:30 p.m., that you tell your attorney, the public defense attorney in the courtroom, that you have 3 open cases, not 2.
Yes, ma'am. I'm currently in the process of trying to find an attorney. I didn't qualify for that one.
Okay. Then let them know you have 3 open cases to be addressed on September 24th. Time is ticking. Today is September 5th. You don't have much time left to give your attorney to prepare.
Yes, ma'am.
All right. Good luck. Thank you.
Thank you.
Is there a Sheila? Oh, sorry. Yeah, Sheila Rosser is position number 3 on the bench warrant calendar. I will take her up next after jail court iPhone. Jail court, who do we have?
We have position number 38, Mr. Brendan Varner.
Okay. This is Brendan Warner, case 24 CR 5810F, accused of violation of certain rules at a bus, rail, or station, and for willful obstruction of a law enforcement officer. Mr. Varner, if you can come closer to the iPhone so we can see you.
Yeah, we got
Your Honor, actually, when I went to the jail yesterday to interview him, he refused to come out to meet with me. So I could not interview him. I don't know if he has a change of heart to interview with a public defender.
All right. Mr. Varner, your case number is 24 CR 5810F. And these 2 charges stem from an August 17th, 2024 incident. You have a bond set at the present time. The question that you are to answer, either through your attorney or you can answer it yourself, is whether you would like to accept the state's recommendation. Looks like it will be time served and to stay away from martyr property, or whether you would like to exercise your constitutional right to a trial and plead not guilty to these charges. What would you like to do?
Time, sir.
I'm sorry?
Time, sir.
Okay. Have you spoken to your attorney about the consequences of pleading time served? Of pleading guilty and getting time served?
I was not able to interview him.
Okay. Would you like an opportunity to speak to your attorney, Ms. Kim?
I already know.
Well, I know you don't know her, but she would like to introduce herself to you and speak with you.
I already know.
You need to look at the screen and tell me your answer. What would you like to do?
Let them know what you want to do.
Time served.
Well, in order to receive a time served, you need to be pleading guilty and understand the consequences of pleading guilty. And the only way you can understand that is by speaking to an attorney.
I already know, understand.
All right. Mr. Varner, you have a right to an attorney. If you cannot afford one, Ms. Kim with the Public Defender's Office is willing to represent you and give you her legal expertise so you have a complete understanding of what the plea means. Now, if you decide to waive your right to counsel and represent yourself, then you are responsible for understanding the law, how it applies to the facts of your case.
Wait.
All right. From now on, if you interrupt me, I'm going to reset your case for 1 more week until you learn your some manners. Do you understand? Again, if you decide to waive your right to counsel, then you are responsible for understanding the law and how it applies to the facts of your case, and how it may apply to any other open cases, as well as to your residency if applicable, and also to the fact that you may lose a job or your housing or any other resources. So would you like to consider speaking to Ms. Kim, or would you like to waive your right to counsel?
Wait.
Again, face the screen and answer my question. Repeat.
Wait.
Okay. And am I to understand that you are waiving your right to counsel?
No.
Yes, for the third time. Fourth time.
Mr. Varner, are you waiving your right to counsel?
Yes.
Ms. Falk, please state the plea offer for Mr. Varner.
Yes, Your Honor. The recommendation is on count 1, time served, which would be 38 days, credit for time served 19 days from August 18th, 2024 until today. On count 2, it would be 12 months, served 38 days, credit for time served 19 days, balance suspended, and that's going to run concurrent with count 1, which means just at the same time. And you would just need to stay away from all MARTA stations because currently there's a lifetime ban in place. That's all for the state.
Mr. Varner, these are the terms of the plea if you decide to plead guilty to these charges. Do you accept these terms?
You accept the charges?
This is time served.
This is a time served offer.
I'm home.
Yeah, but you can't be by no waters.
All right, I said.
This is the last time I'm going to say this. And if you don't listen, I'm going to reset your case for another day. Turn around and face the screen. And remain that way. Do you accept the terms of the plea presently?
Yes.
Do you agree that the factual basis supporting these charges are true and correct?
Yes.
Do you agree that the venue of these violations is in Fulton County?
Yes.
Do you agree that the correct defendant is you, Brandon Warner?
Yes.
All right, Ms. Falk, are you satisfied that he has stipulated to the factual basis, venue, and ID?
Yes, Your Honor.
Mr. Varner, have you consumed any medicine or alcohol recently?
No.
Oh, I forgot one thing, sorry. Please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge? You can put your hand down now? You can put your hand down. Have you consumed any medicine or alcohol?
No.
Have you understood what's going on in your case?
Yes.
Just 1 second. Are you entering a guilty plea freely, willingly, and knowingly? Mr. Varner, are you entering a guilty plea freely, willingly, and knowingly?
Yes.
If you decide to plead guilty, you would have to give up your constitutional right to a trial before a judge or a jury. You will not get the opportunity to go back to court, to have the assistance of counsel, to confront your accuser, to challenge the evidence.
Just say time served.
Mr. Varner.
Just say time served.
The offer is time served, but by law, I have to go through the plea colloquy so that you understand the rights that you are waiving. This is required by law.
I understand.
So listen.
I already get it.
I understand, but I still have to ask the questions as a matter of law. As I was saying, you would have to give up your constitutional right to a trial, to have the assistance of counsel, to go back to court, to confront your accuser, challenge the evidence brought against you, to have the ability to present your arguments, your defenses, and any mitigating factors if you choose to do so, and to have the state carry its burden to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes.
You understand that if I sentence you today, that you would not have the opportunity to appeal this decision?
Yes.
How do you plead to one count of violation of and committing certain acts at a bus rail station?
Yes.
How do you plead?
Guilty.
How do you plead to willful obstruction of a law?
Guilty with time served.
How do you plead to one count of willful obstruction of a law enforcement officer?
Guilty with time served.
On the violation of certain acts at a bus, rail, or station, your sentence is time served, 38 days, credit for time served, 19 days. On the willful obstruction, your sentence is 12 months to serve 38 days, credit for time served, 19 days, balance suspended, concurrent with count 1. Your obligation for this case is over. However, you are required to stay 200 yards away from all MARTA property, including train stations and bus stations. You are not to be seen at any of the MARTA property, including their bathrooms, parking lots, and the stations. And this would be for your lifetime. Thank you.
We can make it any more difficult.
ACDC, who do we have?
I have, this is the composite calendar, Your Honor. Miss Sharika Grady, position 1.
All right.
And
Give me, I'll be right with you.
Thank you.
Courtroom 2, do we have anyone else to address from the SAP calendar?
Oh, I don't know, there's not, I don't think so, but I do have Miss Rosser on the DV bench warrant.
Understood, but I have to address my jail cases first. Miss Grace, could you place ACDC, Miss Falk, Miss McLeod? Mr. Bartel, are you here?
Yes, Your Honor. I'm here in the courtroom and there are no inmates in the courtroom, so I think we could go into a breakout room in courtroom 2.
Kia Burgess, if you could start your video, please.
Okay.
And anyone else joining us in the competency breakout room? All right. Miss Grace, everyone whose video you see on, could you please place us in the breakout room, including ACDC?
Is there any way we can go over the SAP calendar before we do all of that?
No.
Okay. So we have to wait for that court?
That would be, yes.
John, they tell my recording to stop. They ain't did no none on me. Hello?
Ma'am, your case will be heard once the judge come back.
Okay, thank you.
Ms. Champion, we're back in the,
Miss Grady.
Give my charger, I'm back then, so I charge my phone.
Ms. Champion, we finished with the breakout.
Okay.
Thank you.
I have little kids, I have babies.
Ms. Champion?
Yes, Deputy Milton, I'm about to put you in the main breakout room.
Okay, thank you.
Mhm.
They disabled my video.
All right, Sheila Rosser, if you could please unmute and start your video. Sheila Ann Rosser.
Yes, ma'am.
All right, unmute and start your video, please.
Is that it?
All right. Yeah, raise it a little higher so we don't look at your bare legs. Thank you. Thank you. Yeah. Okay. Your case is 24 CR 001 1768, accused of battery family violence from March 11th, 2024. You've got a second open case, 24 CR 5013H, also family violence battery. It looks like you've got a bench warrant in the case ending in 1176H. For failure to appear in court before Judge Taylor on August 22nd, 2024. Looks like you had a prior, you had a prior bond surrender. Let me see what that order says.
I was incarcerated when I was supposed to be in court.
Yes, Your Honor. Well, the bond surrender was because of the second case.
Okay. So then she made new bond on July 24th, 2024. And she didn't appear in court about a month later on August 22nd. Where was she incarcerated on August 22nd?
Your Honor, I don't believe she was saying that she was incarcerated on August 22nd. She didn't receive the notice. If you look at the notice, it was sent to the wrong address. Although her address hasn't changed, and it seems like a typographical error on the clerk's end. It was sent to 2105 Ben Creek Way, and that's not her address. She didn't receive notice for the August 22nd hearing. So I would ask to set aside the bench warrant.
That's not her address, 2105 Bent Creek Way, Southwest Atlanta, Georgia?
Yes, her address is 2105 Bent Creek Way. If you look at the notice that was sent, it was sent to 2105 Ben Creek Way.
Bend with a D?
No, B-E-N.
Bend. It's missing a T. But there was no return to sender.
But it was sent to it wasn't sent to the correct address. So we don't know what happened with it, but it was sent to the wrong address. I mean, the address is not correct.
Okay. Ms. Falk? Please unmute.
My apologies, Your Honor. So it does look like the address does say Ben Creek Way. And although I am skeptical about whether it was received, since the address is incorrect, I do not disagree to a lifting of the bench warrant.
All right. So right now the address on Odyssey says Bent Creek, but for some reason on the envelope, the T was dropped. Is that what you're saying, Ms. Ate?
Well, that's what is the case.
Okay. I'm going to set aside the bench warrant that was issued on August 22nd, 2024. And Ms. Rosser, your next court date will be issued by Judge Taylor to appear for arraignment. And you can take up both their cases at that time.
Yes, ma'am.
All right, Ms. Ate will submit the proposed order. Please be mindful that the bench warrant is still valid.
Yes, ma'am.
For the next 48 to 72 hours. So please be mindful until the order is filed with the courts and uploaded to the GCIC, which is the Criminal Information Center.
Yes, ma'am. And the next court date is when?
I don't know. That will be Judge Taylor. Just out of abundance of caution, you might want to make sure that you check your mail and you call the court every week if there is a problem with, I don't know, with USPS or something. I can't control that.
Yes, ma'am. Thank you for listening to this one.
All right. you're free to go. Thank you.
Bye-bye.
Okay, going over the calendar now on the bench warrant calendar for Mr. Droulet, that's been set aside. For Mr. Morrow, that's been set aside, and Ms. Rossa, that's been set aside. Hey, do you agree with that?
Yes.
Okay.
Yes.
And I'll send those orders.
Okay, then I have another add-on request to set aside a bench warrant, Desmond Sellers. Is there a Desmond Sellers on Zoom?
Judge, Mr. Jordan just informed me that the private attorney, Nicole Fegan, needs that to be reset because she's in trial right now.
Okay, it's reset to next Thursday, September 12th. And please, well, she'll know her client has still got an outstanding bench warrant. So hopefully she knows that the warrant is still valid. Okay. All right, that takes care of the bench warrant calendars. We've already addressed the competency calendar. On the add-on state all-purpose calendar, that was Mr. Friedman, and that was a plea for his 2 cases and his 2 bench warrants, correct?
You said a plea, Judge?
Was it a plea? I don't remember.
No, ma'am. It was
Waiver
amended bond order for $12.50 on each case.
For a total of 2,500.
Okay. Did we waive arraignment and further notice? I didn't write it down. That's why.
Yes, ma'am.
Okay. So it was a waiver of arraignment and further notice for trial for Mr. Friedman, and bond was modified to 2,500. Okay. Now let's go something I may know something about. Position 1, Anderson on the SAP calendar was a waiver of arraignment and further notice for trial. Position number 2 is reset to September 12th, 2024. Position 3, Binns, is a waiver of arraignment and further notice for trial. Position 4, Chen, is a plea. Position 5, Terrence Cody, was a plea. Position 6, Cook, was a waiver of arraignment and further notice for trial. 7, Kevin Davis, was that a release? Or do not bring?
He needs to be reset to the 11 a.m. calendar.
Okay, this is going to be reset to September 12th at 11 a.m. Position, that's position 7 and 8. Position 9 was a plea, and his other case, that's Joseph Edmond, 17 CR 025714E, a possible null process is pending. Would that be correct?
So, Your Honor, that the 17 CR case was transferred to the DA's office. They're working on dismissing their transfer. So the case was correct. But yes, we are working on closing that case out.
Okay. So, Mr. Tay, that's your client?
Yes, Your Honor.
So that's the announcement. I just hope that you're going to keep on Ms. Falk's back and make sure that's done. Okay, thank you. Position 10, Gebru, was a plea. 11, Gordon, was going to be a possible DA transfer. Ernest Lee Gordon.
Yes, Your Honor. Let me just check on something really quickly. I will need to make that request to the DA's office. I'm not seeing where the request was actually made to the DA's office.
Okay, so this case, Miss Grace, has it already been reset to September 10th? Or
I have it for the 12th.
Okay, so Ernest Gordon is reset to September 12th.
Okay, and we are waiting on medical documents, Your Honor. That's why we have not sent that up yet. The DA's office has requested we send it with medical documents.
Okay. So do we need to put it out for another week?
No.
My hope is that I can get these by next week. So let's just reset it to next week, please.
September 12th. Thank you. Derek Grigsby, position 12 was a plea. Position 13 was a plea. 14, Richard Harris was a plea. 15, Christopher Henderson was a plea. 18, Donovan Houseworth, position 16. And that's going to be, you're filing a waiver of arraignment for Donovan Houseworth, position 16, 17, and 18. Is that Mr.
Check, I think it's,
Mr. White?
yes, and, I needed to look back at the announcement.
I'm just looking at the announcements from the PD, so it says not guilty, waive.
Yes, then
Okay.
he'll file a waiver of arraignment.
So 16, 17, 18 is a waiver of arraignment and further notice for trial. 19, Raven Jones was a plea, 20 was Norcross, 21 was a plea, 22 was a plea, 23, Mustafa Miller is 23 and 24. That's a waiver of arraignment and further notice for trial. And that was Miss 23, 24. That's Mr. White as well. So Miss Atay, I don't know if Mr. White has left the courtroom, but could you please ping him and remind him of those?
Yes, he will.
Okay, thank you.
And are those reset, waiver arraignment, not guilty?
Yeah, position 23 and 24, waiver of arraignment and further notice for trial. 25, Latoya Moore is a waiver of arraignment and further notice for trial. And she's got those two other cases, 22 CR 5751E and 6270E, 21 CR. Okay. 26, O'Connor was a plea. 27, Osborne was a waiver of arraignment and further notice for trial. 28, Pelo Hernandez was a plea. 29, Plummer was a waiver of arraignment and further notice for trial. To 30, Travis Ransom is reset September 12th at 9 a.m. SAP calendar. 31, LeVar. That's the one we don't know who his attorney is. Hopefully, we were told Matthew Carrington, but I only know a Carrington Matthews, so hopefully Deputy Milton will get the correct name. 32, Rhodes is
so 31 is reset to what date?
September 12th. I have no more place on September 10th. Position 32, Davion Rhodes is reset to September 12th for a possible plea. This is a reset for behavior and lack of attention. Position 33, Patrick Rogers is a plea. 34, Thompson is a plea. 35 is Norcross. 36, Tessan is a plea. 37 is a plea. 38, Varner is a plea. 39, Wolf. Michael Wolf, what are we doing?
He was released, Your Honor. I was told that he was released.
Okay.
That's what I was.
Miss Grace, can you confirm that? And 40 and 41 were pleas.
Yes, 39 was released and 40 and 41 are pleas. Yes, Judge.
So 39 is further notice for trial. I believe that concludes the calendars, yes?
Yes, Your Honor.
Right, I apologize, it took so long, I have no idea, but well, it's the nature of the beast. Okay.
Judge, I'll try to get this over to you right now.
And I'll try to sign them right away. I've got my queue up.
Yes, thank you.
All right.
And Your Honor, just to let the court know, we prepared a order for Mr. Carson Meadows that I also sent Miss Grace for your signature. So that will conclude his cases.
Sometimes miracles happen. Okay. Thank you. All right.
Thank you, Your Honor.
I'll see you all later. Thank you. Bye-bye.
Thank you.